Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I'm going to be covering the decision in the case of the Queen and Minassian. This has been a long time in coming, but it just came out today. So I'm going to try to get a video out here. The verdict is guilty on all counts, and his not criminally responsible by reason of mental disorder defense was rejected. Of course, you probably already got that from the news or Twitter or wherever you get your news. But I'm going to go through this in a little bit more detail. I've already done videos going through his interrogation. And, in that I kind of predicted that this was the likely outcome because they did a really good job at shutting off potential defenses that he might raise down the road, including the not criminally responsible defense. But I'm going to go through this in some detail. And I'll have comments at various points just to sort of explain what's going on or to give my thoughts. So let's dive in here. So the first thing I kind of want to comment on is just this organization. And you may not care about this quite so much, but I really appreciate it because it lays everything out with paragraph numbers. Paragraph numbers are really useful as a reference because sometimes the page format changes from one publication to another. So lawyers usually refer to paragraph numbers when we're citing things. It indicates sort of what you find where. And when it gets to the final conclusion, did he know it was wrong? This is the key sort of bit. It points us to the actual legal conclusions here. This is really well organized, which really helps me as a reader of law. I wish more decisions would have this, but you as a watcher of this video probably don't care as much. I just wanted to comment on it. So I'm going to dive in here with the justice actually starts out with an introduction and kind of a commentary on society. So I'll talk about that here, and I'm going to read out what she writes. This case has, in many ways and on many days, been a struggle. One of the issues with which I have struggled is that this accused committed a horrific crime, one of the most devastating tragedies this city has ever endured, for the purpose of achieving fame. And he's achieved that purpose. He's told forensic psychiatrists who assessed him that the attention he has received and the information available when you Google his name makes him happy. One doctor asked him how he would feel if his name had never been reported by the media, and he said he would have been very disappointed. Throughout this trial, I have understood the need for these proceedings to be public and transparent. I've also recognized the crucial role of the media to keep the public informed, particularly during the pandemic when it was not easy for members of the public to attend the trial in person. That said, I'm acutely aware that all of this attention and media coverage is exactly what this man sought from the start. In an earlier decision dealing with the sealing of exhibits in this trial, I commented, I, for one, would welcome a consensus among responsible journalists to refuse to publish the names or images of individuals seeking fame by inflicting carnage upon innocent people. I realize that journalists also have conflicting ethical principles to be weighed in the balance. I also know that in this case, long before I started this trial, the name of this accused was all over the media and the internet. His name is also published in several previous decisions I have written in this case. There's nothing I can do to rewind all of that. However, if any case like this should arise in the future, it is my fervent wish that, at the very outset, careful consideration be given to withholding publication of the name of the perpetrator. It would, in my view, be a rare situation in which the public's right to be informed would require revealing the actual name of the perpetrator, or where that limited right would outweigh giving the perpetrator the fame or infamy he or she seeks. In this case, and at this juncture, all I can do is refuse to actually name the accused in my reasons for judgment. It is my hope that his name would no longer be published by anyone else either. That is not an order I will make. It is merely a wish, perhaps a naive one. However, for purposes of this decision, I will refer to the accused as John Doe. Now, let's break this down a little bit. First thing, I think it's unquestionable that fame is a motivation for sort of these types of rare events. People have done analysis. They've actually found that that this is a sort of guiding motivation. This is something that is sought. And so there may be some benefit in hiding the names, but it's going to be very difficult to do that. because the people involved want their names to be out. And so we're going to take steps to ensure that that happens. Particularly in the internet era, it's going to be very difficult to, try to hide that kind of information. It's going to end up being readily available. So this notion that it can be withheld, I think, is one that is actually not possible. The other thing I'll note is that, while the justice is saying that, for the purposes of this decision, I will refer to the accused as John Doe, the proper case citation, of course, is the Queen in Minassian. So it's still getting published. I mean, the guy's name is going to be out there. The other thing that occurs to me when I think about this is, they're saying that it's a rare situation in which the public's right to be informed would require revealing the actual name of the perpetrator. The problem with that is that the relationship between the public and journalism has really changed. Journalism at one point used to be kind of very heavy investigation from the journalists and a real top-down flow of information, where information would primarily flow from the journalists to the public. But there's a real shift. Journalists rely increasingly on the public to find things, to uncover details. And so once the person's name is known, that's part of how people find, for instance, 4chan postings or Facebook pages, including Facebook pages that may be under a different name. Somebody who knows that person can say, I know this guy, and this is his actual page, and look at the stuff here. The public also has some interest in knowing what kind of person this is, so that we can know things like, what do we need to do about this kind of problem? What were the risk factors here? What were the causative factors? And so I'm not sure I agree with the justice in terms of this balancing notion. However, I do understand certainly the desire to see essentially the names of these people just die off, where we just don't hear them. And it may actually be useful in preventing some of these rarer events if their names aren't released. I don't know the proper balance here, but I do have some concern that there needs to be some real thought put into how that balancing act happens. The other thing is, in this judgment, this statement it's kind of a political gesture. It's, because his name is going into the citation. It's part of the head note. And so when the justice says, I'm going to refer to use his name, I wonder if that's not going to be part of grounds of appeal, because having got a verdict, we may well see an appeal come in. And I might be surprised, in fact, if I didn't see some comment about, well, the justice wouldn't even use his name. How can this be a fair verdict? And I don't think that there's bias on the part of the judge or the justice, but I could certainly see somebody making the argument. So that is another thing to think about here. She then goes and names the people who were the victims and also the heroes of the day. So this also, I think, is a potential place where an allegation of bias could be made. I don't think it's one that's, properly justified under the circumstances. That's my personal take. But I think justices need to be careful when they're writing decisions not to open those doors if they can avoid it. Also going to, so Constable Ken Lamb gets a mention for apprehending the accused without incident, even though the accused attempted to provoke him into shooting. Quite frankly, I've seen that, little bit, the little bit we've seen of that, and it is commendable. That was excellent work on the part of the constable. So good job. I'll comment as well on Detective Rob Thomas, who the justice identifies as having interviewed him with a high degree of skill. Absolutely. I commented at several points in the video on how it was an incredibly skillful interrogation. Just, there are points where I was just like, wow, that was really well done. The note here about without ever being disrespectful. I kind of look at that and I say, well, yeah, he wasn't ever disrespectful, but that's not to say that he wouldn't have been. He wasn't disrespectful because it didn't help the detective accomplish his aims. But if it would have, I could have, I imagine that he could have switched to being disrespectful, or even, hostile or confrontational very readily. So the without ever being disrespectful is really more of a comment on what worked in the interrogation. I don't know that I give him props for the high degree of skill. I don't know that the without ever being disrespectful is really the place. Because quite frankly, if he'd come in and adopted a sort of sneering tone or taken shots at the guy, I suspect that it would have been ultimately a way less successful interrogation. The justice goes through some detail in the facts. I'm skipping over most of it. I'll just note that they go through and name all of the people that the accused killed, as well as all of the people who were injured, and as well as details of their injuries here. I will go through this bit here. Following his arrest, Mr. Doe was interviewed by Detective Rob Thomas at 32 Division. Prior to that interview, Mr. Doe was fully advised of his rights, and on 2 occasions he exercised his right to speak to a lawyer. Although there were some questions Mr. Doe declined to answer, he made extensive inculpatory, meaning likely to convict him, statements, including that he'd set out to kill people that day and that he'd rented the van almost 3 weeks in advance, deliberately choosing one that would be small enough to maneuver on the sidewalk, but large enough to inflict maximum damage. He said he was motivated by the incel movement as he had been rejected by women and admitted he frequented incel chat rooms on the internet. He paid tribute to mass murderers ER and Chris HM, with whom he claimed to have been in contact before they died. I find it interesting that the justice names these 2 individuals, but not the accused. When asked if he had anything to say about the fact that he'd killed and injured all those people, he stated, "I feel like I accomplished my mission." I'm not naming those individuals because I suspect YouTube would take issue with me doing so. So given the charge of first-degree murder, this case was originally scheduled to be heard before a jury. Initially, defense counsel brought a motion to have the trial transferred to a jurisdiction outside Toronto, where it was thought it would be easier to find an impartial jury. However, the horror of this incident generated such widespread media coverage that it became apparent it would be impossible to find jury members anywhere in Ontario who had not heard or read about the case. The defense withdrew its motion and sought to have the case tried by a judge sitting alone without a jury, to which the Crown consented. This isn't really surprising. I mean, this was such a high-profile case. I doubt that they could have found jury members not only anywhere in Ontario, but anywhere in Canada who weren't aware of what had happened here. So ultimately, in the interest of having a fair trial, they proceeded without a jury and just with a judge, a justice sitting alone, which we call a judge-alone trial. And the assumption there is that the justice can put these things aside more easily than members of the jury because they've had more practice, more experience in that regard. It was apparent from the beginning that there would not be a significant dispute on the facts. There was extensive video of the van driving down the Yonge Street sidewalk. It was clear Mr. Doe killed and injured those people and that he intended to do that. The central issue was not the acts he had committed, but his state of mind at the time. To that end, there were many psychiatric and psychological assessments carried out, causing adjournments of the trial. By the time the trial was finally set to proceed in April 2020, the COVID-19 pandemic had hit Toronto, resulting in the physical closure of all courts and further adjournment of the trial. New dates were scheduled for the fall, but as those dates approached, all counsel recognized that conducting the trial in the conventional way, in an actual courtroom with live witnesses and spectators, was not going to be possible. Ultimately, all parties involved consented to conducting the trial remotely, using a variety of virtual platforms to accommodate everyone with an interest in the case. So a lot of people have commented about how long this case took. Here's some description as to why, and sometimes things happen. At the beginning of the trial, Mr. Doe entered a plea of not guilty to all 26 counts on the indictment, but indicated that he was relying on Section 16 of the Criminal Code as a defense, and that he was not criminally responsible for these offenses within the meaning of that provision. So this is the not criminally responsible by reason of mental disorder provision, which is often colloquially called the insanity defense. All of the facts necessary to prove the charges of murder and attempted murder were conceded by the defense and were the subject of extensive agreed statement of fact filed as exhibits at trial, some with accompanying photographs and video footage. Mr. Doe planned in advance to carry out an attack by driving a rented van down the sidewalk on Yonge Street with the intention of killing as many people as possible. He then carried out that plan, killing 10 people and injuring another 16 people. There's no doubt that these actions were planned and deliberate. In fact, I think during his interrogation, he actually, admitted the words planned and deliberate, which, when you're actually admitting the legal test, that's not a great place to be. Ultimately, had he not given that interview, it might have been difficult for the Crown to prove first-degree murder, because even with a rental 3 weeks in advance, there might have been some question as to whether he planned it all out 3 weeks in advance, or whether he rented the van 3 weeks in advance and then just decided at the moment to go on the rampage. So his interrogation ultimately was a great help to the Crown. For the individual victims who died, all of the constituent elements for first-degree murder are established. For the individual victims who were injured but did not die, all of the constituent elements for attempted murder are established. Accordingly, the sole issue to be decided at trial was whether Mr. Doe had established, on a balance of probabilities, that because of a mental disorder, he should not be held criminally responsible for his actions in causing these deaths and injuries. So the long and short of that is that he's either going to be found not criminally responsible by reason of mental disorder, or he's getting convicted on everything, because it's admitted that he did the things. Prior to trial, Mr. Doe was assessed by 3 teams of experts, 2 retained by the defense and 1 retained by the Crown. 1 or more experts from each of these teams testified at trial. Numerous expert reports were filed. I also heard evidence from Mr. Doe's father. John Doe was diagnosed as a young child with what was then called pervasive developmental disorder. In more recent years, that name has changed to autism spectrum disorder, ASD. Every expert who assessed Mr. Doe accepted that he is on the autism spectrum, as do I. So that's a finding of fact from the court, and not a terribly controversial one here. I also agree with all the experts that, although some people with ASD can have intellectual impairments, that is not the case for Mr. Doe. He does not have any impairment of his cognitive abilities and is above average in intelligence. To meet the requirements for defense under Section 16 of the Criminal Code, the accused must establish either A, that he has a mental disorder that renders him incapable of appreciating the nature and quality of his act, or B, that he has a mental disorder that renders him incapable of knowing that it was wrong. This is commonly referred to as an NCR, not criminally responsible, defense. All of the experts agreed that Mr. Doe was not psychotic at the time of this attack, nor was he suffering from any delusions. Rather, he was fully aware of what he was doing when driving the car down the sidewalk, and that this would result in the deaths of many people. He also understood that deliberately killing people in this manner would be murder, and that this is a criminal offense. Thus, he appreciated the nature and quality of his actions, and he knew that they were legally wrong. Therefore, the only aspect of the Section 16 defense that might possibly fit Mr. Doe's circumstances is whether, because of his autism spectrum disorder, he was incapable of knowing that his actions were morally wrong. On this issue, there was a division of opinion among the experts, and it is this issue that is the central point for me to decide in this case. And I'm going to jump ahead here because this is sort of an introduction, but I'm going to sort of skip ahead to the actual Section 16 discussion here. I should note that this was quite controversial because there's many people out there with autism and, or who are on the spectrum in some capacity who really don't like being associated with individuals like this accused, and also don't like the sort of implications here. But the court's going to try to grapple with that, and we'll talk a little bit about how they do that. So Section 16 of the Criminal Code states, "No person is criminally responsible for an act committed or an omission made while suffering from a mental disorder that rendered the person incapable of appreciating the nature and quality of the act or omission, or of knowing that it was wrong. Our law presumes that every person is sane and responsible for their own actions, unless the contrary is proven. An accused who claims to be exempt from criminal responsibility by virtue of Section 16 bears the burden of establishing that fact on a balance of probabilities. So there's different legal tests that get articulated in the criminal law sphere. In terms of proving an offense, that has to be done on the basis of proof beyond a reasonable doubt. But here, in order to establish the Section 16 defense, it has to be balance of probabilities, which is more likely than not. And when they say that the burden of proof is on the accused, it's actually on whoever is actually trying to establish that this applies. And there's some circumstances where the Crown might be doing that. But again, it's on the balance of probabilities. They have to show that it's more likely than not. So it's actually a fairly tough test, just because there is the presumption that you're sane. You start out with that as the sort of starting point. So going on. The insanity defense, as it used to be called, and often still is in the media and in people's common understanding, was part of our criminal law long before it was specifically included in the criminal code. It rests on the principle that a person should not be held criminally responsible for something they did when their mind was so deranged that they did not know what they were doing or were incapable of knowing the difference between right and wrong. This could be because A, they did not know the nature and quality of their act. For example, they believed, because of a delusional disorder, that they were killing Satan when in fact they were killing their mother. Or B, because they lacked the capacity to know that that what they were doing were wrong. For example, they believed that they had been ordered by God to carry out the act in order to save mankind, and that therefore what they were doing was going to save a lot of people. However, the defense is founded on the principle that criminal responsibility can only result from the commission of a voluntary act, and that to be voluntary, an act must be the exercise of free will. Now, when they talk about criminal responsibility, that doesn't mean that somebody who's found not criminally responsible by reason of mental disorder is going to be just kicked out the door. It's not like, oh, well, hey, you had a mental illness, off you go, best of luck. Please take your meds. No, it's actually that they get confined to a mental hospital on an indefinite period. There is no release date inherent to this defense. So you stay there until it's established through lots of review processes and so forth that you're not a danger, that you're, that the issue is resolved. That can actually be longer than you might have otherwise gotten on sentencing. Although with this offense, there is not really any such thing as longer than you would have gotten on sentencing, because the sentence is a mandatory minimum of life. And I expect this is probably a circumstance where the terms of parole ineligibility are likely to be run consecutively. I don't expect, unless this verdict is somehow successfully overturned in an appeal, I don't expect that there will ever be release for Mr. Minassian. I suspect he will be in custody until he dies. So skipping ahead a little bit, there's some discussion about voluntariness and a comparison with mental disorder. And I find people tend to find the voluntariness aspect easier to grasp. A lot of people have issues with the notion of mental disorder. They say, oh, well, just because he's mentally ill doesn't mean I don't want this guy locked up because he's dangerous. But that is what happens anyway. But, if you consider some examples, like let's say you're driving down the road and you have a seizure, and that seizure causes you to, swerve and you run over a group of children. Saying that you are at fault for that seizure, most people would find that to be unfair. Or as an example, let's say you're pumping gas and the gas pump for some reason explodes and splashes you with flammable gasoline, and that gasoline ignites. You are now on fire. And in the course of being on fire, you're not really paying a whole lot of attention to where you're going. All of those lessons about stop, drop, and roll have been forgotten right now. And you just run because you're in pain. You're trying to, cognitive thought has been shut down. And because of that, you run into another, into a store. You're, desperate for somebody to help you out. But because you're on fire, you set fire to that store, causing damage. We would say maybe this isn't arson if you were on fire and just running around in a panic. It wasn't intentional. It wasn't voluntary. You didn't really have another option. So that's kind of our ideas behind these punishments, is that if you're incapable of, navigating these questions, that you are not criminally responsible, but you may still need to be detained in order for the public good. This is really taking you out of the punishment sphere and putting you into a public good sort of assessment as to whether or not you ever get release. All right, continuing on. The focus in this case is on the second branch of the NCR defense, specifically whether Mr. Doe was suffering from a mental disorder that rendered him incapable of knowing that his acts were wrong. Issues arise as to the interpretation of three terms: mental disorder, knowing, and wrong. So the court is going to spend a lot of time assessing that. And if you are a future law student, I can almost guarantee that this case, because it goes into some substantial detail about the tests here, this case is going to end up in law schools and law texts. This is going to be a case people cover. So I guess if you're a future law student watching my video, hi, and good luck on your exams. And good luck with getting articling jobs and all the things that law students stress about. And I don't miss it all, and I'm sorry you're having to deal with right now. Anyway, meaning of mental disorder. Again, this was super controversial as to whether autism could qualify. So the court is going to be treading very carefully here. The first requirement for the NCR defense to apply is that the accused was suffering from a mental disorder. The criminal code provides no tangible assistance on what conditions qualify as a mental disorder. The definition section of the code merely states that mental disorder means disease of the mind, which obviously does not advance the analysis. Thank you, criminal code, for defining a mental disorder as basically a mental disorder. Yay! So that's been left to the courts. As far as I'm aware, and counsel have been able to determine, no Canadian court has determined whether autism spectrum disorder is a mental disorder within the meaning of Section 16 of the Criminal Code. It is therefore necessary to approach this question by reference to first principles. So they're going to logic this out. That's great. That's what courts are good for. And, this is what I like to see with courts. So I'm happy to see things so far. Before turning to that analysis, I wish to address the terminology. The language used in the criminal code referring to mental disorder and disease of the mind and to people suffering from such a disability is rooted in case law going back decades or more. I will use that language not because it is consistent with modern perceptions of disability, but because these are legal terms that have particular meaning in this context, as developed over many years of jurisprudence. This is fairly common. Language in the law evolves slowly because language in the law has meaning that is more than just the words used. And so a particular turn of phrase ends up being defined in a way that is critical, and where a slightly different but sounding like it means the same thing turn of phrase might actually have a very different meaning. So it's important to get the terminology right. The justice here is kind of noting this may be offensive to some people, and we're sorry, but we're stuck with it. There's various other places where this comes up. Status Indians being an example. Like, you wouldn't say that outside of a legal context, but it's a legal term, and we're stuck with it in terms of the law. So my next point flows from the previous one. The meaning of the term mental disorder or disease of the mind in this context is a question of law. It is a determination that draws on medical information, but it remains a legal issue, not a medical one. Further, it may change over time as the science evolves or societal and policy considerations evolve. The fact that a condition is regarded to be a mental disorder by a psychiatrist may be persuasive, but it is not determinative. So they're saying this is a law question. Doctors are helpful, but they don't get to decide the issue. There is some assistance in the case law as to the meaning of mental disorder or disease of the mind, but no solid definition emerges. In Cooper and the Queen, the Supreme Court of Canada acknowledged that the term disease of the mind has eluded satisfactory definition by both medical and legal disciplines. The court held, however, that the term should be given a broad and liberal construction, noting that the reason for requiring a disease of the mind was to exclude drunkenness, conditions of intense passion, and other transitory states. The court held, in summary, one might say that in a legal sense, disease of the mind embraces any illness, disorder, or abnormal condition which impairs the human mind and its functioning, excluding, however, self-induced states caused by alcohol or drugs, as well as transitory mental states such as hysteria or concussion. Hysteria is probably not a term that would be used these days. In order to support a defense of insanity, the disease must, of course, be of such intensity as to render the accused incapable of appreciating the nature and quality of the violent act or of knowing that it is wrong. So, broad and liberal construction means basically we don't want to exclude things unnecessarily, but there was some stuff that they were specifically trying to exclude. You know, when they say intense passion, they mean just because you're real mad and you really, really badly want to punch someone in the face doesn't mean that you can use the, not criminally responsible by reason of mental disorder defense. Even if you're so mad that you're not capable of thinking of anything other than punching this person in the face. So, and, drunkenness, drugs, all excluded. This makes some sense. So they're saying that, lots of things will fall into this definition anyway. In the Queen and Bouchard-Lebrun, the Supreme Court of Canada considered whether toxic psychosis flowing from a voluntary ingestion of drugs fell within the rubric of mental disorder for the purposes of Section 16. The court noted that medical science continues to evolve and that it will undoubtedly never be possible to define and draw up an exhaustive list of the mental conditions that constitute diseases of the mind within the meaning of the criminal code. The difficulties that have arisen in defining this term have related to conditions like automatism or sleepwalking, or self-induced states from consumption of drugs or alcohol. Those difficult issues of interpretation do not arise here. Fundamentally, however, conditions that have an organic or internal cause are more likely to be seen as qualifying for the defense. A qualifying mental disorder may be permanent or temporary, curable or incurable, or recurring or non-recurring. However, conditions that are permanent, non-curable, and recurring are more likely to qualify. Again, when we think about it, that fits in with what the court has been saying about things like consumption of drugs or alcohol. That would be something that is temporary, curable in the sense of just stop doing it, and non-recurring in that if it's not something that happens on its own. So those kinds of considerations become highly relevant here. Autism spectrum disorder is a neurodevelopmental disorder that presents in early childhood and continues for life. The manner in which ASD presents may change over time, and some deficits may attenuate with treatment. An individual with ASD may learn through treatment or life experience to manage or compensate for some of the deficits caused by the disorder. However, there is no cure per se, and the condition is permanent. Some individuals with ASD may also have varying degrees of an intellectual disability. However, sometimes there is no impact at all on intellectual function. Now, I'm just going to chime in here and also note that the whole notion of a cure, which is used in scare quotes by the justice, but that's an incredibly controversial notion because there's lots of people who are neuroatypical, and I'm also, neuroatypical, who would not be thrilled by the notion of a cure. There are plenty of aspects of how I think that I think are beneficial, desirable, that I would not want anyone to mess with. However, and I'm attention deficit, there are things I struggle with, and some of those things are, internal struggles that are, difficulties I have in terms of accomplishing things. And some of those are external struggles in the sense of society maybe doesn't know how to deal with people who are like me. So the whole notion of a cure gets really ugly. And if such a thing existed and there's no prospect of it, and that would be incredibly controversial. So I'm not going to opine here on the benefit, but it becomes part of the legal, consideration here, and that is going to be a political firestorm if such a thing ever sort of comes into being. All of the experts who testified particularly noted the theory of mind deficit experienced to some degree by all persons with autism spectrum disorder. They struggle to understand the emotions or perspective of somebody other than themselves, or to put themselves in somebody else's shoes. As a result, they frequently lack empathy for the suffering of others. Dr. Bradford pointed out that, unlike psychopathy, the empathy deficits experienced by people with autism spectrum disorder are actually caused by the disorder. They lack the capacity to have empathy. Okay, kind of have some concerns with this description, but carrying on. Psychopaths have the capacity to understand the emotions of others, but typically either ignore those emotions or manipulate them for their own advantage. There's some other, descriptions of, autism aspects. Social category can include things such as reduced ability to share emotions, deficits in understanding nonverbal communication, difficulties maintaining and understanding relationships, inability to adjust behavior to suit various social contexts, and inability to empathize with others. Typical behaviors in the second category, which are sort of the more physical category, include repetitive motor movements like flapping of hands, echolalia, insistence on sameness and rigid adherence to routines or ritualized actions, and highly restricted fixated interests that are abnormal in intensity or focus. So that's the restrictive, repetitive patterns of behavior or interest aspect. So these are sort of the court trying to describe what they're dealing with. They also talk a little bit about the DSM definitions. Severe deficits in verbal and nonverbal social communication skills cause severe impairments in functioning, very limited initiation of social interactions, and minimal response to overtures from others. This is the DSM most severe category of requiring very substantial support. It doesn't describe all people on the spectrum. For example, a person with few words of intelligible speech who rarely initiates interaction, and when he or she does, makes unusual approaches to meet needs only, and responds to only very direct social approaches. Inflexibility of behavior, extreme difficulty coping with change, or other restricted repetitive behaviors markedly interfere with functioning in all spheres, great distress or difficulty changing focus or action. Again, that is describing the most severe category of requiring very substantial support. So when they say autistic spectrum disorder, they're referring to the fact that it can be much less impactful on people's lives or much more impactful. Now, they're looking at some case law, and they weren't able to find a whole lot, but they did find one case that we're going to talk about a little bit here. Dr. Bradford was aware of only one Canadian case dealing with ASD and Section 16 of the Criminal Code. He testified that this case involved a young offender, JF, and that he believed the NCR finding was made on consent. Counsel were able to track this case down. Dr. Bradford was right about the determination at the trial level. JF had been charged with arson and other charges in youth court. Defense counsel sought a mental health assessment, which was shared with the Crown. It was the Crown who sought to have JF declared not criminally responsible. Defense counsel did not oppose the determination, and the NCR finding was made. The young offender appealed. One of the grounds of appeal raised was that the psychiatric report was based on Asperger's disorder, which is not a reasonable basis for an NCR finding. However, the Court of Appeal decided the case based on another ground of appeal, essentially that the young offender did not have effective representation by counsel, who acted more as a social worker believing a mental health outcome was best for JF, without proper instructions, and even though there was an available defense to the charges. It was on this basis that the Court of Appeal set aside the NCR finding, with the justice stating for the court, I need not determine whether the NCR verdict was based on a flawed psychiatric report and is unreasonable in light of the disposition. So I'm going to comment a little bit on this one because this is a situation that really, in my view, illustrates the importance of defense counsel, because defense counsel should be acting for the best interests of the accused themselves. But they need to take instructions. They need to act. It's the accused who decides what their best interests are, not the defense counsel. So this was, I mean, the suggestion here is that the defense counsel was not doing their job of acting as a defense lawyer, but instead was trying to act as a social worker. That's a very damning indictment. And so basically they threw the case out, or they threw the finding out, because the defense lawyer was not providing proper assistance, was not doing their job. And so they didn't actually get to the question of whether Asperger's, which is now sort of recognized as part of the spectrum, would qualify. Ultimately, this case ends up being fairly useless because of that problem. It's unfortunate. In the absence of Canadian precedent, it is useful to consider how the issue has been dealt with in other jurisdictions. So this is something that happens from time to time. Canadian law recognizes that legal decisions from other countries may be persuasive. They may be useful for helping the court come to a decision in this particular case. That's most often the case where we don't have sort of good decisions from here in Canada, but there's not really a limit to that. You can look to other cases or other jurisdictions, and sometimes they'll look to other jurisdictions and say, they do it this way and that works out well, or they do it this way and that works out badly. So there's all sorts of potential here, and the court has already identified that there's only the one case in Canada that anyone knows about, and it's not a good case. So we're going to have to look elsewhere. So they say there's two American decisions. In one of them, the court stated, to the extent that the Asperger's evidence was aimed at defeating an inference of Cottrell's intent from the circumstance, it was relevant and could have assisted the jury's determination of whether Cottrell had the specific intent required for aiding and abetting. And in another case, a California Court of Appeal also concluded that the trial judge had erred, so they made a mistake, in limiting the application of a psychiatric opinion on the impact of the accused's autism spectrum disorder on his ability to form the intent on charges of conspiracy to commit murder and solicitation to commit murder. The court held that the expert's opinion was relevant and probative of the issue of whether the accused had a mental disorder that affected his ability to form the requisite intent, and it would have then been for the jury to determine whether he did, in fact, have that intent. So they carry on to look at New Zealand. In New Zealand, the equivalent of our Section 16 defense requires the existence of either natural imbecility. When I was talking earlier about, the language not evolving and maybe being a little offensive, yeah, there we go. But I mean, that's just kind of the way law is. Sometimes, okay, moving on. Or a disease of the mind that renders the person incapable of understanding the nature and quality of the act, or of knowing that the act is wrong. The trial judge had held that autism spectrum disorder, because of its broad spectrum that could include people with no intellectual impairment at all, could not fall within natural imbecility. In the result, the judge, I think it was, accepted that Mr. 2 had a disease of the mind comprising a combination of autism, high functioning with theory of mind problems, and some cognitive impairment, and schizoaffective disorder. However, the trial judge left open the possibility that even without a comorbidity, such as a psychosis or intellectual disability, acute forms of autism might qualify as a disease of the mind. The justice wrote, "Given the foregoing, I consider that autism is not a disease of the mind in the ordinary sense used by psychiatrists or psychologists, and is not generally a disease of the mind. It is a developmental disorder that does not cause psychosis, delusions, or incapacitate cognitive function, except perhaps in severe cases. But in theory, at least, a low-functioning person affected by severe autism or a high-functioning person with severe theory of mind problems may be incapable of understanding what he or she is doing or to rationally form moral judgments. In this much more limited sense, some forms of autism might qualify as a disease of the mind. What I take from the jurisprudence that does exist is that the question of autistic spectrum disorder supporting a defense to criminal responsibility is a novel one in other jurisdictions, not just our own. So courts are grappling with this in more than one place. Having looked at this, I find that autistic spectrum disorder qualifies as a mental disorder within the meaning of Section 16 of the Criminal Code. It has an internal cause rooted in the brain and often has a genetic link. It is a permanent condition that is always with the individual, as opposed to being transitory. There are treatments that can provide a person with alternative mechanisms to deal with the deficits with varying degrees of success. However, it is clear that with or without treatment, autistic spectrum disorder has an impact on brain functioning and thought processes. In its severe manifestations, and particularly where there are comorbidities, ASD might, and they underline that, cause a person to lack the capacity to appreciate the nature of an action or to know that it is wrong. It is not possible to rule out ASD at this threshold stage by holding that it cannot ever qualify as a mental disorder under Section 16. Obviously, that is by no means the end of the analysis, but only the beginning. The existence of a mental disorder is merely a first step. There must also be a causative connection between the disorder and the incapacity referred to in one of the two Section 16 branches, i.e. incapable of appreciating the nature and quality of the act, or incapable of knowing it is wrong. The particular manifestation of the condition on the individual, as well as all of the surrounding circumstances of the offense, will determine whether it applies in any given case. Not every person diagnosed with ASD will be eligible to assert the defense, just as is the case with any other disability routinely accepted as the kind of mental disorder that qualifies. For example, schizophrenia. Everything depends on the particular circumstances of the individual and how they are affected by their disability. So the court is kind of hedging, in my view, around the language. They're saying, well, it's not always going to be excluded. So what they mean is that it kind of does qualify as a mental disorder for the purposes of Section 16. However, they're basically saying that the circumstances where it's going to qualify as a mental disorder are the circumstances where you're going to meet some other branch of the test. So we can't rule out people with ASD as qualifying, based on the mental disorder element here. Now, this is likely to be controversial because, amongst other things, the term mental disorder is going to be bound up with all sorts of pejorative meanings in society. And it's important to note that when the court is saying mental disorder here, quite frankly, I think that if this justice was really able to use different terms, they would have preferred to. But that's the legal term that we're stuck with, and they're stuck with it in terms of Section 16 of the Criminal Code. It doesn't apply to, whether a layperson would consider this to be a mental disorder or any other term, or even necessarily to other areas of law. It's just particular to this Section 16 analysis. They're also not saying that all people on the spectrum are going to qualify. What they're saying is that some people on the spectrum might qualify, and therefore the simple notion that autism on its own means that you are disqualified from an NCR diagnosis, they're rejecting that. That's it. They're just saying that it is possible that somebody might have a particular manifestation of an autistic spectrum disorder. They may be at some particular point on that spectrum where they might qualify for this. So I think that that's a very hesitant statement. It's a very sort of small statement as opposed to a large, broad statement. And my feeling is that the justice is trying very hard to qualify that statement and to limit the extent of it. And I think that that's fair. I am concerned with how the media is likely to pick up these elements of the decision. And, certainly as somebody who, I don't have any sort of spectrum diagnosis, but I do have I will say that several elements of the spectrum kind of feel like maybe somebody's talking about me. And I definitely do have an attention deficit diagnosis. So I'm in the range of neuroatypical somewhere. I am always kind of concerned with how media portrayals happen. And I will say that the media is fairly often unfair to people on the spectrum. They either like to present people as these super genius, awkward super geniuses that, of course, then everyone has trouble living up to. And it's like, why aren't you this super genius like, whoever on TV? Or else as completely unable to function. Whereas most people who are in some way neuroatypical fall within the giant realm that exists between those points. We are people with strengths and weaknesses struggling to make it in a world that, may not always see us as whole people and may not always be built for people, who are different. So I'm glad to see the justice. I like the way the justice approached this in terms of essentially saying, we're not going to exclude people, but I'm also not going to make any broad sweeping statements. I like that. I think it's the right tone. I think it's the right sort of place to land in the decision. I'm still really concerned that it's going to get misrepresented, including by well-intentioned people, by people who are advocates, but might not be seeing the legal implications of kind of what and how the justice is trying to navigate what I will say is a very thorny, difficult issue. So that's a bit of a mouthful, and I recognize as well that I'm sort of a person trying to navigate this myself, and that I may not always be the best at doing so. If if you're somebody who's affected by this decision because you're in the larger community, and if you think I'm screwing up here, let me know, because I'd always like to do better. I know that, I don't want to be the guy who's adding to anyone's struggles. So let me know. I'm trying to do my best. I think the justice is trying to do her best, but we're going to have some ongoing dialogue with respect to this one. Continuing on with meaning of knowing. The first branch of the Section 16 test involves a capacity to appreciate the nature and quality of the act, whereas the second branch refers to a lack of capacity to know that it is wrong. In drafting the legislation, Parliament used two different verbs, appreciate and know, rather than the same verb in relation to both branches. As a basic principle of statutory construction, it is presumed that Parliament uses language carefully and consistently within a statute. There is a presumption of consistent expression, which requires giving the same words the same interpretation throughout a statute. Conversely, if different words are used, particularly in close proximity to each other, they are presumed to have different meanings. The case law has confirmed this to be true. So this provides a sort of concrete example when I was saying before that the court has trouble changing language because language ends up being so bound up with meaning, and the meaning itself is very particular to the precise language used. This is an example. Appreciate and know are going to have different meanings because they are different words. And, if Parliament meant the same word, they would have used the same word. This is kind of how law works, but I think this is a good example of what I was talking about before. As noted by the Supreme Court of Canada and Cooper, in contrast to the position in England under the McNaughton rules, where the words used are knows the nature and quality of his act, Section 16 of the Code uses the phrase appreciating the nature and quality of an act or omission. The two are not synonymous. The draftsman of the Code, as originally enacted, made a deliberate change in language from the common law rule in order to broaden the legal and medical considerations bearing upon the mental state of the accused, and to make it clear that cognition was not to be the sole criterion. emotional, as well as intellectual awareness of the significance of the conduct is an issue. They continued, to know the nature and quality of an act may mean merely to be aware of the physical act, while to appreciate may involve estimation and understanding of the consequences of that act. And they give an example here that is from that case law, which was of choking, and noting that the person in that case may not, or may have been capable of intending bodily harm, but not necessarily of knowing that that it might cause her death. So that's sort of one example here. Similarly, in Barnier, the Supreme Court of Canada held that the trial judge erred in instructing the jury that know and appreciate were synonymous. The court held that to appreciate embraces the act of knowing, but the converse is not necessarily true. They reviewed various dictionary definitions and noted the verb know has a positive connotation requiring a bare awareness, the act of receiving information without more. The act of appreciating, on the other hand, is a second stage in a mental process, requiring the analysis of knowledge or experience in one manner or another. It is therefore clear on the plain meaning of the section that Parliament intended that for a person to be insane within the statutory definition, he must be incapable, firstly, of appreciating in the analytical sense the nature and quality of the act, or of knowing in the positive sense that his act was wrong. And skipping over a little bit of sort of specific case law, in part because I suspect YouTube would not appreciate it if I went into that. Thus, it is clear from the case law that appreciate in the first branch of the test is a broader concept than know in the second branch. It should be noted, however, that when these distinctions were being drawn in Cooper, Barnier, and Kjeldsen, the accepted interpretation of wrong in the second branch was restricted to legally wrong. As I will develop in the next section, the law on that point has changed quite significantly since that time. So what they're getting at here is that knowing and appreciating is a different thing. You can have an intellectual impression of something and yet not really understand it. And that sort of greater degree of understanding is required here. It's not sort of a huge leap from know to appreciate. These are kind of down the street, not in different cities, but they are different things. It is another step that must be taken. So, meaning of wrong. Prior to 1977, there were conflicting decisions in Canada as to the meaning of the word wrong in the second branch of the Section 16 defense. The Supreme Court of Canada addressed the issue in Schwartz and ruled in a 5-4 split decision. So that's a real close decision, but 5-4 split decision may mean that the Supreme Court may come back to it later, but it's still good law. I mean, the lower courts are not going to be able to reject Schwartz on the basis of, well, it was real close, so we're not going to follow that. Those split decisions are more of interest to academics and to potential places where the law might evolve or change over time than they are to what the law is right now. That the trial judge was correct in instructing the jury that wrong meant forbidden by law and did not encompass the concept of moral wrongfulness. There was a vigorous dissent authored by Dixon, with Laskin, Spence, and Beets concurring, in which the minority opined that wrong, as used in Section 16, included the capacity to reason and to reach rational decisions as to whether the act is morally wrong. So that was prior to 1977, and things are going to evolve as we see. The issue again came before the Supreme Court of Canada in 1990 in Chalk. 2 teenage boys had been convicted of murder. There was expert evidence at trial that the boys suffered from a paranoid psychosis, believing that they ruled the world, and that although they knew the laws of Canada existed, believed they were above that law, because, they're rulers of the world and Canada's little laws don't affect them. The trial judge instructed the jury, in accordance with Schwartz, that wrong meant contrary to the laws of Canada, which basically meant you guys got to convict. That's sort of what that would end up with there. By the time the case reached the Supreme Court of Canada, there had been an almost complete turnover on that bench, with Dixon, the only member remaining of the court who had also sat on Schwartz. This time, in Chalk, the majority of the court specifically overruled Schwartz. So Schwartz, no longer good law as of the Chalk decision, agreeing with its dissenting judgment, and held that wrong meant morally wrong in the circumstances according to moral standards in society, and that the question to be determined was whether an accused was incapable of knowing that the act committed was one that he ought not to have done. So skipping ahead a little bit, I'm cutting a bunch out here because I know that this video is already sort of clocking in at over an hour. It's probably going to be a very long video that you may want to watch sort of in sections because very long. But I'm cutting out as much as I can and still trying to give the gist of what's going on here and an understanding of the law. But I always recommend, if you've got the time and the interest, read the original case, because it's going to be able to go into everything where I'm skipping over stuff. An interpretation of Section 16 sub 2 that makes the defense available to an accused who knew that he or she was committing a crime, but was unable to comprehend that the act was a moral wrong, will not open the floodgates to amoral offenders or to offenders who relieve themselves of all moral considerations. First, the incapacity to make moral judgments must be causally linked to a disease of the mind. If the presence of a serious mental disorder is not established, criminal responsibility cannot be avoided. Secondly, as was pointed out by Dixon, moral wrong is not to be judged by the personal standards of the offender, but by his awareness that society regards the act as wrong. The accused will not benefit from substituting his own moral code for that of society. Instead, he will be protected by Section 16 sub 2 if he is incapable of understanding that the act is wrong according to the ordinary moral standards of reasonable members of society. So this is a kind of important distinction, because let's say you've got somebody who is who believes that a particular group of people in society needs to be wiped out. Let's say they hate lawyers and they think that it's a good thing personally. Their personal belief is that it's a good thing if they kill all the lawyers. Please don't do that. I really don't appreciate being murdered. I tend to object to that. But let's say that is their view. But so long as they're still capable of understanding that this is not society's view, I mean, society doesn't always have a great view of lawyers, but typically, as much as sometimes there's jokes about, dead lawyers or whatever else, typically people recognize that murdering lawyers is wrong. Again, please don't. I appreciate being not murdered. So continuing on, but that I think is an important distinction as to why they're saying we're not just opening the floodgates to everybody who just says, well, I disagree with society, so I'm going to kill whoever I want. That's one of the things the court was trying to avoid here. A further refinement was added by the Supreme Court of Canada in its unanimous 1994 decision in Uman. I hope I'm pronouncing that right. The accused in that case was convicted of second-degree murder after he shot a guest in his apartment as she lay sleeping. He was suffering at the time from a psychosis with paranoid delusions, believing that a local union was out to get him, and that the victim had been commissioned by the union to kill him. At the time, the accused had the intellectual capacity to understand right from wrong and would know that killing a person was wrong. However, his delusional state led him to the conclusion that the killing was justified under the circumstances he believed to be real. And so they stated the question, this appeal poses the following legal issue. What is meant by the phrase, knowing that the act was wrong in Section 16 sub 1? Does it refer only to abstract knowledge that the act of killing would be viewed as wrong by society, or does it extend to the inability to rationally apply knowledge of right and wrong, and hence to conclude that the act in question is one which one ought not to do? So as a general principle, killing people is wrong. I think that as a sort of general principle, we can agree on this. However, there are situations that are exceptions. And so, let's say you're at home late at night and a ninja breaks in, and that ninja is there to kill you. There's not a whole lot of ninja-related crimes in Canada, although we do have a lot of ninja-related laws for reasons that are beyond me. But let's say you are the first person in Canada that is being attacked by said ninja, and you, in self-defense, shoot and kill the ninja before they get to you, which is impressive. That, typically people would view as not morally wrong. That is a self-defense thing. However, your belief that this was a ninja might have, in fact, been the result of mental disorder. And so, that's where this sort of distinction comes in here, because, what happens if your particular understanding of the situation is such that, the standard application of knowledge of right and wrong kind of goes by the wayside because of your particular circumstances. So that's kind of, I guess, what they're trying to get at here. Ultimately, the court decided that the capacity to apply the knowledge of wrongfulness in a rational way was part of the test, stating, the crux of the inquiry is whether the accused lacks the capacity to rationally decide whether the act is right or wrong, and hence to make a rational choice about whether to do it or not. The inability to make a rational choice may result from a variety of mental dysfunctions. As the following passages indicate, these include, at a minimum, the states to which the psychiatrist testified in this case. Delusions which make the accused perceive an act which is wrong as right or justifiable. So again, if you think that somebody in your house is a ninja and that they're there to kill you, you would perceive that act as right or justifiable, even by societal standards, right? Society, if you were being attacked by a ninja, would probably be okay with you using force to defend yourself. Probably. But, if you're wrong and it's actually, you're not even in your own house, you've broken into someone else's house, you're completely out of it, and, you've just attacked the homeowner, so you're wrong about it being right or justifiable, you may still fall within the not criminally responsible by reason of mental disorder framework. So, and a disordered condition of the mind which deprives the individual of the ability to rationally evaluate what he is doing. It should be evident that we are not here reverting to the thesis that knew it was wrong means judged it wrong in the light of his own conscience. Such a definition could never be acceptable in a viable criminal law. As the courts have rightly insisted, it is a public standard of wrong that must be used, whether public law or community morality. What we are saying here is that knowing the nature and quality of the act, or that it is wrong, in the context of insanity, and thus rationality, means having the capacity to rationally assess, define, and evaluate his own particular act in the light of the relevant public standards of wrong. So just because you personally think that it's okay to shoot anyone who steps onto your property, and you shoot the mailman, that doesn't make it okay. That doesn't make it that you fall within the not criminally responsible by reason of mental disorder. That would be, so long as you can understand that society does not view that. The preceding comments should not be taken to mean that a person is not responsible if he holds irrational beliefs, for that is not the case. The point is that if the person has a mental makeup which is such that he lacks even the capacity for rationality, then responsibility is vitiated. If he has the capacity but simply fails to use it, responsibility is not precluded. So they identify 4 principles from that case. First, under a Section 16 analysis, the focus is not on the accused intellectual capacity to know right from wrong in the abstract sense, but rather on the capacity to know that a particular act was wrong in the particular circumstances of the case. The issue is whether the accused possessed the capacity to know that the act in question was morally wrong, having regard to the everyday standards of the ordinary person. An accused cannot be said to know something is wrong within the meaning of Section 16 if, because of a mental disorder, he lacks the capacity for rational perception and hence rational choice about the rightness or wrongness of the act. This does not excuse psychopaths or any other persons following their own deviant code of behavior because they choose to do so, rather than because they are incapable of knowing that their acts are wrong in the eyes of society. Now, if you are a regular viewer and you have already seen the Minassian interview tapes and my review of them, you probably already know, this bit here, these 4 principles, pretty much are going to end the case. However, the court's going to have to apply these principles to the specific circumstances of the offender. But, when they start talking about like this 4th principle here, and I just skipped ahead by accident. So when they talk about this 4th principle of, other persons following their own deviant code of behavior, that's, I think, a big problem here. Similarly, there were several points where the investigator basically got admissions that the accused knew that everyone else would judge this action to be wrong, and that they went ahead and did it anyway. So right here, I'm seeing, even if the court hadn't already sort of told us what the verdict was, this bit here, if you were still waiting for the court to say whether they were going to, convict or find NCR, this here is a bad sign for Mr. Minassian. In my view, Uman, as interpreted in the judgments of this court, holds that an accused who has the capacity to know that society regards his actions as morally wrong and proceeds to commit those acts cannot be said to lack the capacity to know right from wrong. As a result, he is not NCR, even if he believed that he had no choice but to act or that his acts were justified. Mr. Bytensky, on behalf of the defense, that's defense counsel, and I've seen a lot of people bashing defense counsel on this, and don't. Defense counsel's job is to provide a defense and to say, you don't get to lock someone up unless you have done your job, and that everybody is, our system is built on this assumption of two sort of competing forces, and whoever has the best argument, which is probably because they have the best facts, is going to prevail. But it's essential that somebody be there in the court to say, maybe that didn't happen, or, maybe you're wrong, or, this is a critical role in our society. So it's not a bad thing to defend people, including people who are accused of very serious bad stuff. So I don't approve of the commentary that basically says that Mr. Bytensky is a bad guy. On the contrary, he's doing a very difficult and necessary and often thankless job in society. And, he did not have a great set of facts here to work with. This is a very hard case. A lot of lesser lawyers might have said, I'm just going to pass on this one, because it's not likely that I'm going to end up at the end of this sort of walking out being the triumphant winner. This is like, if you were looking at this case from the outset, it's probably like, well, I'm going to work real hard on this, I'm going to be slammed in the media, and I'm at the end of the day going to lose. That's still important. It's still like, this is critical, and Mr. Bytensky is not to be condemned. He's to be praised for having, taken and run with what he had as best as he could. It looks to me like he put in a lot of work. It looks to me like he did a hell of a job. But ultimately, the facts here were just such that, it was overwhelming. But his role in this is essential. It's necessary, and it's commendable in my view. So anyway, Mr. Bytensky, on behalf of the defense, argued before me that the Court of Appeal decision in Dobson is incorrect in law, inconsistent with the binding decision of the Supreme Court of Canada in Uman, and inconsistent with other decisions of the Court of Appeal. He submitted that I should not therefore follow it. Mr. Callahan, for the Crown, agreed with that position. As a general proposition, where there are conflicting decisions in the Court of Appeal, I clearly must choose between them. Further, if one line of decisions is consistent with the Supreme Court of Canada's jurisprudence and one is not, I must follow the decision of the Supreme Court of Canada and the appellate decisions that follow it. I am persuaded by counsel that Dobson is not correct in its interpretation of Uman, and further, that other decisions of the Ontario Court of Appeal are inconsistent with the position taken in Dobson. Accordingly, with the greatest of respect for the court in Dobson, I have decided that I will not apply their reasoning in this case to the extent they depart from Uman. In light of the implications of such a decision, it is incumbent on me to set out my own reasoning in some detail. So there's the Dobson case, and this court is saying, I don't think Dobson is right. I'm going to not follow it. And because they're sort of breaking from the court's, from a previous court, they're going to put some effort into explaining sort of why. I'm going to skip over the facts of Dobson because I don't think that's super essential, and it will bog us down quite a bit. So there's a whole lot here. Our Court of Appeal has put it more succinctly, saying that a subjective belief by the accused that his conduct was justifiable will not spare him from criminal responsibility, even if his personal views or beliefs were driven by mental disorder, as long as he retained the capacity to know that it was regarded as wrong on a societal standard. It is not sufficient to decide that the appellant's act was the result of his delusion. Even if the act was motivated by the delusion, the appellant will be convicted if he was capable of knowing, in spite of such delusion, that the act in the particular circumstances would have been morally condemned by reasonable members of society. So let's take a step and think about what, as an example of this. Let's say that you have, some sort of mental disorder and it's causing you delusions. And those delusions are that you think that your neighbor hates you. And you think your neighbor spends a lot of time sitting up at night, mocking you with his friends and, just generally being a jerk, but not doing anything, that is a direct threat. They just, you think your neighbor hates you and makes fun of you and so forth. And so as a result of that, because of that delusion, you go over and you attack your neighbor. Here, you would still know that that's condemnable, because even though your neighbor is being a jerk and hates you and whatever, you're not allowed to go and attack and kill your neighbor. So that's sort of an example of something that might be motivated by a delusion, but still something that you'd be aware would be morally condemned by reasonable members of society and would not provide a defense. So carrying on. And again, skipping over a whole lot of stuff. You can see how much I'm skipping. Read the case if you wish to go over it, but I'm trying to give you sort of the essentials. Further, if the test under the second branch of Section 16 is restricted in the manner suggested in Dobson, I agree with the observation of the trial judge that it would have little meaning in a case involving a serious crime such as murder. The more serious the crime, the greater the overlap between knowing something is legally wrong and knowing that society would view it as morally wrong. If an accused had the capacity to appreciate the nature and quality of his act, killing someone, and knew that it was legally wrong, it is hard to imagine a scenario in which he would be incapable of knowing that society would regard it as morally wrong. In my view, this is not in keeping with the ratio of the decision in Uman, nor with the reasoning of the Supreme Court in Bouchard-Lebrun, see paragraph 59. Uman requires that the intellectual knowledge that reasonable members of society would consider killing someone to be morally wrong. All right, so that kind of gives us an overview of what they're talking about here, and the court is going to be following these kinds of general principles. Dobson suggested perhaps a departure back to sort of a legally wrong aspect, but there has to be some sort of capacity to understand the nature and consequence. They say there is at least one significant case since the Court of Appeal decision in Dobson that has taken Dobson as authority for the proposition that the test in Section 16 for what constitutes the capacity to know the act is wrong does not include the capacity to make rational choices. That may or may not be a correct interpretation of Dobson. However, if it is what Dobson stands for, in my view, that is not consistent with Uman, nor is it consistent with the Court of Appeal's 2012 decision in Sostak, which I, again, hope I'm pronouncing right. So the court is saying they are bound by Uman, and that's what they're going to follow. All right, so next we're going to get into a whole bunch about the accused life, and I'm going to talk in fair detail about this. Unfortunately, I'm not doing this to celebrate the accused in any fashion, but when we're assessing the court's decision as to whether this particular accused falls within the definition of NCR, it's kind of required to know the particulars of this accused. It's going to be very precise and targeted down to this, but I am recognizing that there is some scientific evidence that suggests that some of these people are motivated by kind of a desire to be known and a desire to be famous and a desire to be kind of seen in a world where they may feel that they have not been seen. But we're kind of stuck here. I don't really see a way around this in this particular circumstance. So I'm going to go through what the court says and sort of try to make sure we've got enough of a basis to understand the ultimate verdict. The defendant's life prior to April 2018. John Doe was born on November 3rd, 1992. He has one sibling, a brother 3 years older than him. He grew up in a supportive family home in Richmond Hill and was still living with both parents and his brother at the time of the attacks in 2018. Both parents are university graduates and engaged in meaningful employment for most of their lives. Both parents appear to have been highly attentive to his needs as a young child through school and into adulthood. He had a particularly close relationship with his older brother, and they would often socialize together, even as adults. Other than issues associated with his autism spectrum disorder, his childhood appears to have been happy and uneventful. Early childhood. Symptoms of ASD emerged at an early age. These included difficulty interacting with other children, repetitive movements, head banging, delayed ability to speak, lack of emotion, and no eye contact. He had speech therapy, as a result of which he finally began to talk at about age 3.5. As a small child, he would have violent temper tantrums, but he grew out of those before starting school. School years. Mr. Doe's parents sent him to an Armenian preschool, then a private Montessori school for junior kindergarten, and then a local public school for senior kindergarten. He had difficulty interacting with the other children at these schools, problems doing anything independently, and failed to meet the expectations for the class and social norms. Sometimes he would run out of the classroom and have to be brought back. As a result of concerns about his behavior, he was referred to Markham Stouffville Hospital at the age of 5, where he was diagnosed with pervasive developmental disorder not otherwise specified, a term that has since been replaced by autism spectrum disorder. When he was 6 and entering grade 1, Mr. Doe was admitted to Giant Steps, a specialized elementary school program for children with ASD, with a goal to provide intense, almost one-on-one support and assistance, leading to the child's eventual integration into the mainstream education system. Now, I know that Mr. Minassian is not going to show up on their list of distinguished alumni anytime soon. If Giant Steps is still in operation, because of course this is many years ago, it does appear that they succeeded in the goal of getting him integrated into the mainstream education system. So don't judge them too harshly here. He was gradually worked into a regular classroom concurrently with the Giant Steps program, and by the end of elementary school was in the classroom full-time, but with special education assistance. This continued through high school. Mr. Doe attended a mainstream public high school, but was in a special education class for part of the time and received support from special educators to complete classwork. Throughout his school years, Mr. Doe continued to struggle with social interactions. He had above average intelligence, was good at mathematics and science, and had an excellent memory. Even in kindergarten, he was able to add 3-digit numbers in his head. However, subjects like English and history were more challenging, particularly where any kind of analysis was required. He would have difficulty summarizing the main point of an article or story, and would often go off on a tangent or recite irrelevant segments. Socially, Mr. Doe improved somewhat as he went through school. He had one close friend in elementary school, but lost touch when they went to different high schools. He also had a friend in high school who was also in a special education class. He was the target of bullies in school. His response to bullying was to behave in a goofy way, such as using a high-pitched, silly voice, and laugh along with his bullies. Sometimes he would act out in this way simply to gain attention. Throughout school, he had difficulty in social relationships, never dated as a teenager, and had very few, if any, close friends. When in high school, Mr. Doe started to develop physical and verbal tics and engaged in a number of repetitive rituals. He was diagnosed with Tourette's syndrome and was on medication for a brief period. He disliked the side effects and went off the medication. Eventually, he outgrew this behavior. As is often associated with ASD, Mr. Doe had some motor coordination issues. He was awkward in his movements and not good at sports. He did not have good fine motor skills and was accommodated in school by being permitted to type his exams because handwriting was difficult for him. He was also given a longer period of time to complete exams. Mr. Doe graduated from high school with a 70% average. He did not have to repeat any of the grades, although it took him 5 years to complete what would usually take 4. Mr. Doe's father testified that John would sometimes develop fixations on things. He played video games incessantly. Sometimes he would memorize the whole text of a video and recite it. Although his family did not know it at the time, it was during high school that Mr. Doe developed an interest in school shootings and other mass murders and spent a lot of time on internet sites dealing with this issue. Throughout all of this time, there was never any hint of violent behavior. He was described as gentle and shy, never aggressive. Now, one thing I'm going to caution about here is that people love to look into the backgrounds of people who have done terrible things and sort of identify things and say these are, the causes or these are risk factors that we should look for. Ultimately, though, his upbringing was not super exceptional. A number of the things in his upbringing I actually look at and I find are common with my upbringing. I actually had I was permitted to type my exams, and did so even in law school for some exams because I have issues with handwriting. I am also a socially awkward kind of guy. Some of that was a little close to home. But all of these things, the problem is that these are extremely rare behaviors. The violence in question here is an extremely rare behavior. The stuff that's going on in his childhood is maybe not, universal or super common, but it's also not super rare. And so what ends up happening is it becomes really easy to sort of look at these risk factors when in fact the predictive value of anything that I've seen thus far is very low. And we can actually cause a great deal of harm to people if we look at stuff like this and assume that it has more predictive value than it does, because what it can end up meaning is marginalizing further the vast majority of people who are on the spectrum who do not go on to commit violence. In fact, from what I can tell, being on the spectrum is associated with less risk of committing violence, not more. So we don't want to end up with a situation where people are assuming that, these spectrum kinds of behavior indicate that you're violent, because that can result in people acting badly towards people on the spectrum in ways that they shouldn't. So that is something I will always throw out as a caution here. It's a real problem. The same thing happens when they talk about, fire starting, bedwetting, and harming animals. There was this big craze of saying that, kids that do this are going to grow up to be, dangerous killers. In actual fact, what it turns out is that those are behaviors that sometimes are shown by kids who have been badly abused. And so that sort of notion of that sort of deadly triad, the predictive value of it was almost nothing. So low, in fact, that it's useless as a predictive factor. But it resulted in the targeting of some children who had been victims of abuse. And, the last thing children who have been victims of serious abuse need is further targeting by society and, being shunned or considered to be dangerous when they're not. So that's sort of my concern with stuff like this. University. Mr. Doe went to Seneca College, where he graduated with a degree in computer programming, a subject at which he'd always excelled. His marks were better than in high school, B's and A's. He found that he fit in better socially with other students in his program, many of whom he also described as nerds. However, he had no close relationships. A couple of attempts at trying to talk to a girl or ask her out failed from the start. He took an extra year to complete his degree, but that was partly due to a couple of failed exams and the fact that he switched majors partway through. Employment. Midway through university and subsequent to having failed a few courses, Mr. Doe suddenly decided to join the military. His parents and brother knew nothing about these plans until he'd already made the decision to enlist, and were very surprised at the choice, as it seemed out of character. A few weeks into basic training, Mr. Doe concluded that he was ill-suited to military life and negotiated an honorable discharge. He then returned to Seneca College and completed his degree. While in college, Mr. Doe had a part-time job that seemed to go well. He also did a co-op work-term placement as part of his degree requirements, which he completed successfully. In 2016, however, he was fired from a job due to his work performance, specifically because he was playing video games while at work. Mr. Doe's explanation for this was that the work was easy, and he completed his assignments quickly and then started playing video games rather than asking for additional assignments. While in his final term of university, Mr. Doe undertook a job search and accepted an offer of permanent employment with a reputable company doing software development at an annual salary of $60,000. He was scheduled to start that job not long after the subject offenses. So the next bit is titled The Impact of Autism Spectrum Disorder on the Defendant's Life. I'm going to be covering a fair bit about this, again, because it's really important to see the specific things the court's looking at. I'm going to skip over sort of as much as I can, but I think this illustrates as well the very thoughtful and nuanced way the court is dealing with competing expert evidence, because there's multiple doctors who are providing reports here, and the court has to assess them and decide which ones to rely on and how much and on what. And all of that gets really complicated. But I think that people tend to look at the media and they see cases like this and they kind of get a bad idea of what's happening in these cases. I don't think that that's really a fair assessment. And I think that this case will really illustrate just how much care goes into this and how carefully these sorts of things end up getting scrutinized. So let's dive in here. The impact of autism spectrum disorder on the defendant's life. As has been said over and over in this trial, there is no fixed profile as to how ASD will affect any particular individual. There are some common characteristics and traits associated with the disorder. However, not every individual will have all of these characteristics, and the variances, even within the same type of characteristic behavior, are infinite. Further, an individual will not have the same degree of impairment within all fields, such that a person may have marked limitations in one area, no impairment at all in another, and moderate impairments in others. No two people are the same. Therefore, determining how ASD affected Mr. Doe is a very individualized assessment. So a lot of the media has basically been saying like, oh, well, is autism NCR basically? And that is not at all the reasoning that the court is going to run with. You've got to look at the individual and with an incredible degree of care. I'm not sure exactly how long this trial took, but it was not a quick trial. There was a lot of material heard, a lot of detail went into it. This is a very difficult task for the courts, for the doctors involved, for everybody. Mr. Doe is highly intelligent and functions well in terms of independent daily living. He required supportive therapy to overcome some of the repetitive and idiosyncratic behaviors often associated with ASD in early childhood. However, with those supports and with assistance through school, he was able to graduate from high school with good standing. With even less support, he was able to complete a university degree in computer programming. He was able to accomplish all of this because he is above average in almost all aspects of intelligence, with scores even higher in areas of mathematics and logic. The question is the extent to which he has been able to compensate for those deficits or learn to adapt them in order to function in daily living. The fact that Mr. Doe has been successful in his academic endeavors does not mean that this has come easily to him. He did require substantial assistance. Also, he was always given extra time to complete things. He was accommodated in this regard by giving him extra time to write exams and allowing him to use a keyboard to compensate for his difficulties in dexterity and fine motor skills. Also, he took an extra year to complete high school, not because he failed grades, but because he took a reduced course load. Likewise, in university, he took a lighter course load and took a longer time than usual completing his degree. Some of the effects of Mr. Doe's ASD are readily apparent upon meeting or observing him. Although Mr. Doe occasionally uses inflection and gestures when speaking, for the most part he speaks in a monotone and with a stilted manner of speech. A lot of people who watched the Minassian interview commented on that. He's got an unusual affect. He struggles to maintain normal eye contact. Sometimes his eye contact is overly intense. Often in describing something, he will focus on minutiae while missing the bigger picture. In the course of the experts' assessments of Mr. Doe, many standardized tests were administered, some of them several times as each team of assessors gathered their own information. There were some differences in the results, but nothing of great significance. Common themes emerged. Some differences in the results is kind of a useful thing in terms of, if the results are greatly different, then that might be something of concern. But some variation is going to be expected just because retest variability is a thing. One common theme is that although Mr. Doe generally tested at average or above average in IQ, his scores on various components of the test were not uniform. He scored quite high on verbal comprehension and mathematics, but quite low on processing speed, and was at or below average in perceptual reasoning. The processing speed issue is an interesting one and provides confirmation of his experience in high school and college. The assessments show that Mr. Doe has significant deficits in his ability to engage in social interactions and reciprocal conversations. He is often unable to interpret the expressions on people's faces or their tone of voice and has difficulty understanding other people's emotions. These difficulties in social settings have been a lifelong problem for Mr. Doe, who had few friends, an extremely limited social life, other than with family members or playing video games, and no romantic involvements. Although all of the experts noted these deficits, they were not unanimous on the severity of these deficits for Mr. Doe, nor did they agree on the extent of Mr. Doe's insights into his own deficits. So skipping over a little bit here, he administered something called the Vineland 3 test. The one doctor, that's Dr. Westphal. There's going to be a few different doctors involved in this, and so I'll try to keep it separate here. Nobody else administered the Vineland test. Dr. Wright, the psychologist who worked with Dr. Woodside, took exception to describing an adult person's level of functioning as equivalent to a child's age range. In fairness, Dr. Westphal himself acknowledged a degree of discomfort with this kind of analogy. However, Dr. Westphal persistently described Mr. Doe's interactions and communications as being like those of a child. Dr. Wright testified that these descriptors are very misleading and do not accurately depict what Mr. Doe is actually able to do. Further, he disagreed strongly with Dr. Westphal's assessment that Mr. Doe communicated in a childlike manner. And if you remember, if you watched the sort of interview, he doesn't seem to communicate. Childlike wasn't really what struck me in terms of watching that. I mean, these are experts. I am certainly not an expert in psychology or psychiatry. I do have an undergrad in psychology, but just sort of as a layperson, it didn't come off as childlike here. Dr. Wright was also quite critical of the usefulness of the Vineland test in this context. He explained that the test is completed entirely by family members, in this case, Mr. Doe's parents. In addition, when it is done in an adversarial context, it is clearly in the best interest of the scorer to portray their loved ones as disabled. Typically, the test is used where the individual has intellectual disabilities and is designed to show what the person can and cannot do in daily living. It looks at what the child was able to do at points in his life and sets a score based on that, without regard to the fact that the child subsequently learned to adapt in other ways and achieve significant things, such as complete university. The test does not provide any credit for those achievements. So we can see some problems with this test here. And in particular, Mr. Doe's or Mr. Minassian's parents probably have some motivation to help him out. So maybe a test that, for instance, might include a lie scale. Some psychological tests will include kind of hidden subtests that are designed to try to catch things like catching people faking good or faking bad. But it doesn't appear that this is one of those tests. Dr. Woodside also disagreed with Dr. Westphal's characterization of Mr. Doe's interpersonal skills as being like those of a child. Dr. Woodside agreed that Mr. Doe struggles in this area and that it is difficult for him to read people. He uses his intellect to compensate for some of these deficits, but he's unable to completely overcome them. However, he found Mr. Doe to be high functioning and said that he had learned strategies to deal with his limitations to some degree. Dr. Westphal described Mr. Doe as often being baffled when asked a question and being completely unable to answer. Dr. Wright had no such problem, and Dr. Woodside completely disagreed with Dr. Westphal as well. Dr. Westphal was unable to point to any of the videos of his interviews where Mr. Doe exhibited this supposed bafflement. So we can already see there is some, court assessment of the, of the claims here. The court's going to continue to sort of do some weighing there, and you'll see how that goes. So, court says, I reject Dr. Westphal's evidence about Mr. Doe being baffled and unable to understand the questions he was asked. So, court says that's not true. That we don't agree with that. We're not. That's not the case. That's not a finding of fact we're making. I've watched and read a number of excerpts from those interviews, and it seems to me that Mr. Doe understood the questions and answered them in a meaningful and responsive manner. I accept the evidence of Dr. Wright and Dr. Westphal on this point. That I'm wondering if this is an error, if they meant Dr. Woodside, but regardless. It may certainly be the case that Mr. Doe was confused about questions he was asked from time to time, but this would not have been the norm, and when he was uncertain, he asked for clarification. I didn't, from my own personal perspective, I didn't see any questions where Mr. Minassian appeared to be baffled in the police interview either. I also reject Dr. Westphal's evidence about Mr. Doe's communication skills being on the level of a small child. I prefer the evidence of Dr. Wright and Dr. Woodside on this point, and I find their opinions to be supported by the evidence. They described Mr. Doe as being socially awkward and stilted in his conversational style, which in my view is a more accurate description of Mr. Doe's interaction in the various videos I have seen. I also agree with Dr. Wright that the Vineland scores are not helpful to the questions I have to answer in this case. There are many times in Dr. Westfall's testimony when he appeared to be more of an advocate than an objective expert witness. That is kind of the kiss of death for an expert witness, because expert witnesses are supposed to be assisting the court. They're supposed to be providing information. They're not supposed to be lawyers. They're not supposed to be in anyone's corner other than just the truth. So, I mean, notwithstanding the fact that an expert witness may be called by one side or the other, they have sort of a higher duty in that regard. So when the court says that somebody's acting as an advocate, that's a problem. That's a credibility and a, weight of evidence sort of issue. But this statement may not seem like it's really a big deal, but it's a really big deal. That is not a statement, if you're an expert witness, that you ever want the court saying about you. Continuing on, this issue of childlike communications is one example. Dr. Westfall raised Mr. Doe's communications during his interview by Detective Thomas. Dr. Westfall noted that Mr. Doe behaved like a child by invoking his right to remain silent after getting legal advice, but after that continuing to answer questions. I completely disagree with that assessment. Much of what Mr. Doe told Detective Thomas was untrue. He told him those lies deliberately to buttress his overall plan to depict the killings as being connected to the incel movement, and thereby get more media attention. He used things from the Elliot Rodger manifesto and passed them off as his own, and lied about being in touch with Rodger and Harper Mercer. He also provided some significant truthful information about how he planned the attack. However, he continued to refuse to answer some questions that could affect the privacy of others, such as his family members. Dr. Westfall stated he thought Mr. Doe got baffled by the police officer continuing to ask questions. Again, in my view, that opinion is completely inconsistent with the tapes of the interview. The other thing I'll note is that it's not really childlike to get played by a police investigator. Most adults who end up in a police in that small room there, getting interviewed, as the police like to call it, get played by the investigators for the same reason that most amateurs who enter into the ring with a heavyweight boxer, a heavyweight boxing champ, are not going to win that fight. Detective Thomas is an expert in his field. He's highly skilled. He's highly practiced. I was impressed by watching him work, notwithstanding the fact that we're on very different ends of the sort of spectrum there. Like, I'm a defense lawyer. He's a detective. We're in very different fields, but I can still recognize that was really skilled work. And so it's not childlike for somebody to get, tripped up by that. Adults, that happens to adults all the time, including adults without any sort of cognitive impairment. Again, the best thing to do, and I've said this in many videos and I'm going to continue saying it, is just to be a wall, to not give anything, because it prevents, getting tripped up, getting sort of bogged down. So I don't really take that as childlike either. And I think that the court would have had a lot of experience watching police interview videos. And so, yeah, that one just kind of seems strange to me as an assertion. Dr. Wright provided compelling testimony about Mr. Doe's ability to use his intelligence to solve abstract moral reasoning problems. One of the tests he administered to Mr. Doe was the Sociosexual Knowledge and Attitudes Tool Revised, which is typically used to assess people with difficulties in social functioning. The subject is shown pictures and is required to make judgments about sexual mores and appropriate behavior. Dr. Wright testified that Mr. Doe reasoned his way through this process, talking out loud as he was doing so, which he commented is not unusual for people with ASD. The fact that Mr. Doe verbalized his thinking process allowed Dr. Wright to see how his theory of mind was operating. He testified that even though Mr. Doe has no true dating experience, he was able to reason his way through every problem and answer each question correctly, although sometimes taking a long time to get there. Dr. Wright concluded that Mr. Doe has considerable theory of mind, noting that theory of mind is a question of degree rather than either you have it or you do not. The report notes that he scored in the average range or above, but demonstrated challenges with motor speed. Dr. Wright reported similar findings. It took Mr. Doe longer than usual to work his way through the problems. Again, however, Dr. Wright was assisted by listening to Mr. Doe talk his way through the problems, thus showing his actual reasoning process. Dr. Wright testified that the purpose of the sub-tests he administered was to get a sense of how literal the person's thinking is, whether they are able to understand underlying concepts, not just the concrete words. On the Proverbs test, Mr. Doe was required to explain what a proverb meant and was scored for accuracy for how abstract his understanding was. He scored in the average range, but was quite slow in coming to his answers. However, in the multiple choice component of the same test, he answered quickly and perfectly. Overall, Dr. Wright found that Mr. Doe has a relative strength in his understanding of non-literal meaning as compared to other people with ASD, and has strength in cognitive flexibility as compared to the average person. His weakness was that he had to talk his way through the test and took longer to complete it. However, he did not score below average on any aspect of the test. And this is kind of notable because we're talking about allegations that he had substantial time to plan and think about what was going on. So him being able to reason things out might be a bit of a problem for his NCR defense. Dr. Westphal did not agree that Mr. Doe was able to overcome any of his social deficits by the use of his superior intellect. In his opinion, Mr. Doe's cognitive ability merely masks how disabled he is in social communication, abstract thought, and theory of mind, or perspective taking. Dr. Westphal testified that, because of his ASD, Mr. Doe is completely incapable of putting himself in the shoes of another person, seeing their perspective on something, and understanding how they might feel. That testimony is consistent with the conclusion portion of his report, in which Dr. Westphal wrote, "By virtue of the severity of his social cognitive deficits, he was not constrained by any understanding of the impact that his actions would have on his victims, their families, and his own family." Similarly, he wrote, "Most importantly, Mr. Doe's actions reflect that he did not and does not have any understanding of the actual real-life impact of his actions on his victims' families and friends, and his own family, a direct consequence of ASD. I will deal first with Mr. Doe's capacity to understand his parents' perspective. There's slightly more information about this in the earlier part of the report, where Dr. Westphal states that Mr. Doe seemed surprised when asked about any impact his actions might have on his family, but then said they would be affected emotionally 100% by what he had done and by the fact that he was no longer at home with them. However, he felt that they could move on, would not be affected financially, and would only be affected 5% in their daily lives. Which is probably not accurate, because I suspect that the impact on his family is going to be quite substantial. If nothing else, that the name is going to be kind of infamous going forward. Unfortunately, I find that the report does not disclose the full information Dr. Westphal had about Mr. Doe's understanding as to how his parents would feel. So, do you think that's a good thing if you're an expert to have said about you? That's an ouch right there. Does not disclose the full information. That's sort of a suggestion that he's not being candid with the court. In cross-examination, Dr. Westphal acknowledged that what he had recorded in his own notes was that Mr. Doe said that his parents would be affected emotionally 100% because they know I have done this terrible thing. That does not appear in the report. Also in cross-examination, Dr. Westphal was referred to 2 occasions during his interviews when Mr. Doe used the word devastating to describe the impact of his actions. There is video of one of these occasions. Dr. Westphal asked Mr. Doe if they felt bad about what he did. Mr. Doe replied, "I know that what I did was morally wrong and extremely devastating and irreversible." When asked if he knew this at the time of the attack, he confirmed that he did. The other occasion on which Mr. Doe used the word devastating is confirmed in Dr. Westphal's notes, in which he records Mr. Doe as saying that he hid what he was doing from his parents because if they knew, it would be devastating. What we can see here is a lot of sort of the underlying what happened in the cross-examination, because this, I think, is showing that the Crown conducted a cross-examination with a great deal of skill and a great deal of success, because it looks like they were able to point to specific things in this doctor's report to sort of untangle and kind of pull away at the threads and it looks like it had a great deal of effect on the court here. Dr. Westphal explained why neither of those devastating references were in his report. He testified that he did not believe Mr. Doe understands the word devastated the way most people would, and that the use of the word does not mean he has any insight into how his parents would feel. I reject this explanation. Dr. Westphal is not doing well so far in terms of, on the scoreboard of which explanations were accepted and which were not. Mr. Doe has an excellent and sophisticated vocabulary. He does not have to have experienced emotional devastation himself to know the meaning of the word. Dr. Westphal further explained that his understanding about Mr. Doe's reference about his parents finding out was not that he thought his parents would be devastated, but rather that they would stop him from carrying out his plan, which would be devastating. It is difficult to assess this explanation as it comes only from Dr. Westphal's notes. His interpretation of his own notes is more likely to be correct than what would appear logically to be the case. However, I do note and I regret that I have to say this, Dr. Westphal was not always objective in his approach to the issues and tended to cite only those things that supported his theory, ignoring things that contradicted it. I will develop this point further later in these reasons. Ouch. Yeah, that's, as a defense lawyer, that's not something you want to hear the court saying about your own expert. And, basically they're saying that the expert kind of stepped into the role of advocating a position rather than objectively and dispassionately looking at the evidence, which is what they're sort of hoped to do. In addition, during cross-examination, Dr. Westphal was taken to an excerpt from his December 12th interview with Mr. Doe, in which Mr. Doe shared further information about what he thought about the impact on his parents. The essence of this exchange was also omitted from the report. The interview went as follows. Did you think about the impact it would have on the lives of people that you loved after? I knew they would be very upset and disappointed. Disappointed in the same way they would be disappointed if you didn't do well on geology, or I think to a much higher degree. And did you think about what they would carry for the rest of their lives? My parents might feel guilt. Where did I go wrong? Did I let him think this is okay? Why did he do this? So knowing that, what do you think now of the cost-benefit analysis in retrospect? I think I was deliberately ignoring them, that I wanted to rationalize doing this. I just decided that I would go ahead and do it anyways. Now, remember that 4-part test, that the court identified earlier. How are we feeling about this statement right here in terms of that? Yeah, this is, I was ignoring the consideration is kind of mirrors the direct language the court used of when you're not going to be covered by NCR. Notwithstanding what Mr. Doe actually said about his parents, or said about what his parents must be going through, Dr. Westphal continued to maintain in his testimony that Mr. Doe did not actually understand at all how his parents would feel. I find that Dr. Westphal has overstated the extent to which Mr. Doe was unable to predict and understand how his actions would affect his parents. It is clear Mr. Doe has difficulty in the area of perspective taking and empathy. He does not have to have a full appreciation of the feelings of others. He does not have a full appreciation of the feelings of others. However, I do not accept Dr. Westphal's position that Mr. Doe was incapable of any understanding of the impact of his actions on others. Based on what Mr. Doe has said, it is clear that he has some understanding of the emotions of others, particularly when he has time to think about it and bring his intellect to bear. That does not mean that his understanding is innate, or that it is the same as a person without his impairments. However, I do not agree that it is completely missing. Dr. Woodside testified that Mr. Doe told him he believed his parents would be shocked by what he had done, and that he felt guilty about his father being upset. Dr. Woodside accepted that as accurate, as do I. So far, the Crown experts appear to be doing a lot better in terms of being accepted by the courts than do the defense expert. There is less tangible evidence that Mr. Doe was able to take the perspective of the victims or their families. I suspect that this was considerably more difficult for him than putting himself in the shoes of his parents, with whom he had a close and loving relationship. However, even with this considerably more abstract group of strangers, there are examples in the evidence of Mr. Doe showing some understanding of how they would feel. I have already referenced Mr. Doe's use of the words devastating and irreversible to refer to the harms of the victims. On another occasion, He referred to understanding how the child of a victim who was killed would feel, stating that would be obviously very upsetting. He then added, "If I was 8 years old and my parents got hit by some random attacker, I would be upset too." Dr. Westphal asked him to put himself into the position of a family member and think about how he would feel. Mr. Doe said, "I guess depending on their individual temperament, I would either be extremely grief-stricken or maybe even extremely angry. But I mean, I guess with my temperament, I would probably be extremely grief-stricken." An even more striking example of what I consider to be a considerable degree of insight can be seen in the interview of December 12th. Dr. Westphal had asked Mr. Doe what he would say if he was given the opportunity to speak with survivors of the attack. Mr. Doe answered, "I don't know what I would say. The appropriate thing might be to apologize. But if I do that, they might have a hostile reaction and say that this is not sincere in what you're saying, and that it might sound disingenuous." When again pressed by Dr. Westphal as to specifically what he would say, Mr. Doe responded that he would have to tell them the truth because trying to say anything fancy or made up, it's going to be very offensive to them. When again pressed about what the truth was that he would tell the victims, Mr. Doe said he would say he was isolated and bitter at society, that he felt left out and without friends since elementary school, and that he wanted to achieve some notoriety, that he was desperate for approval. He also acknowledged that what he did was stupid and did not make him powerful, but rather that he was weak compared to the victims and their families. Which is a lot of insight there, right? That's a fair degree of insight in my view. This, in my view, is an example of Mr. Doe being able to use his intellect to process information that he might not fully appreciate on an emotional level. It strikes me as being insightful. Dr. Westphal, however, dismissed it as mere words that Mr. Doe used without truly understanding what it meant to be grief-stricken. He stood by the conclusion in his report that Mr. Doe did not have any understanding of the perspective of his victims. When cross-examined about his failure to include any of these statements made by Mr. Doe in his report, Dr. Westphal explained that his role is to provide opinion, not to record facts. Dr. Woodside recognized that Mr. Doe has an impaired ability to understand the perspective of someone else and that it is a difficult thing for him to do. However, in his view, this ability is not completely missing. It is just more superficial than it is in most people. He does not experience empathy or understanding of other people's emotions innately, but he can reason it out using his intellect if given time. Dr. Wright was of a similar opinion. In my view, this is a more balanced assessment of Mr. Doe's capacity to understand the perspective of others, and I am persuaded by it. And that there, I think, is, case is done, but the court's going to go through a fair bit of further analysis, and so will we. I think it's useful to see what's going on, to see the court doing its work. I think that I gained some respect for the court system when I started reading cases, and as much as there's places where I think decisions are made, not all decisions are made well or carefully, but I think on balance, almost all of them are, and it can be quite useful to see a decision like this where the court goes through their reasoning in a lot of detail and see the work being done. Show your homework, I guess, is the thing here, and I think it's really helpful. That said, I am mindful that every expert who assessed Mr. Doe was struck by his complete lack of emotion or remorse when discussing these horrific acts. I fully accept that Mr. Doe is remarkably lacking in empathy. The evidence is overwhelming that Mr. Doe was profoundly lonely. Both Mr. Woodside and Dr. Wright commented on the fact that Mr. Doe's intelligence permitted him to understand that he was different and what his social limitations were. He said he never expected to have a spouse or a family. This left him without any hope for his future. I agree that this message comes through clearly from what Mr. Doe told his assessors. And loneliness is a poison. It's a really difficult thing to deal with, to get through. So that seems to me to be a much more coherent motivation here. I also note, as was commented on by many of the experts, that Mr. Doe was extremely hard on himself, a harsh self-critic. According to the experts, this is not all that common in people with ASD, who often tend to see others as responsible when things go wrong. Mr. Doe, however, was critical of himself for procrastination, failing courses, and generally being a failure in life. As is often the case with ASD, Mr. Doe had a number of areas of fixed interest or hyper-focus as a child. For example, he went through a period of time when he was fixated on Mr. Bean and memorized whole routines that he would perform. Most of these fixations waned as he got older, although he was still hyper-focused on video games. In high school, he developed an intense interest in mass murders. He regularly visited internet sites devoted to this interest and memorized statistics, as well as fantasizing about committing a mass murder at school. He reported that he did not visit these sites as much once he started university, but picked up his interest again in the months preceding his April 2018 attack. In addition to mass murders in general, he had a hyper-focus on Elliot Rodger and his manifesto. The experts were all agreed that this was an area of hyper-focus for Mr. Doe. Some went so far as to say it was obsessive. Mr. Doe kept his interest in mass murders, the incel movement, and Elliot Rodgers a complete secret from everyone in his life. Because, of course, people would not react well to that. Dr. Westphal stated in his report that Mr. Doe has a rigid and concrete thinking style, and that his thinking is intellectualized, out of touch with emotional experience. As was the case with other aspects of Dr. Westphal's report, there was no reference to statements made by Mr. Doe that appear to contradict the categorical opinions stated in the report. I will refer to two exchanges to illustrate this point, one concerning Mr. Doe's newfound interest in religion, the other relating to his understanding of the content on certain internet sites. At page 51 of his report, Dr. Westphal wrote, "No doubt Mr. Doe's plan was conceived in the context of his saturation with provocative, hate-filled material on the internet. ASD made him less able to appreciate the theatrical, exaggerated nature and extremeness of the material or the dark humor behind some of it. He took it very literally." It is difficult to reconcile this statement with what Mr. Doe actually told Dr. Westphal about these sites. In fact, Mr. Doe told Dr. Westphal that people on these websites were joking about what they said they were planning. In explaining one of these sites, Mr. Doe told Dr. Westphal that it was laid out like Wikipedia and warned him that some of the content was offensive. He told him that a small part of it does joke about mass killers and that it is mostly satire. In a subsequent interview, Mr. Doe said, "I have enjoyed reading these stories. They did give me entertainment." When these excerpts were put to Dr. Westphal on cross-examination, he stated that what Mr. Doe told him was different from what he actually knew, and that he stood by his report in which he said that Mr. Doe took everything literally. Needless to say, Dr. Westphal is entitled to his opinion on this, but I would have seen it as a more reasoned and objective opinion if he had at least revealed in his report that Mr. Doe had said the exact opposite to this position. I reject Dr. Westphal's opinion that Mr. Doe took everything on these websites literally. He very clearly knew that much of it was satirical, exaggerated, and dark humor. So, I mean, the court here is saying, he left out stuff that directly contradicts his views. That's a bit of an issue. There's some discussion about sort of biblical discussion. I'm going to skip part of that. To be honest, I know that what I did is worse than like some of other more minor stuff. This is in discussion about whether or not there's a possibility of him being redeemed. It is, realistically speaking, it would be considered extremely irredeemable, like 99% chance irredeemable, but nevertheless, I'm still reading the Bible every day. Nothing about this exchange is mentioned in Dr. Westphal's report. When it was put to him in cross-examination, he denied that this showed abstract thought by Mr. Doe. Earlier in his testimony, Dr. Westphal had said that Mr. Doe had become religious since his incarceration. On cross-examination, Crown Counsel suggested to him that this was not the case, and that Mr. Doe claimed in this discussion that he was not religious and did not believe in God. Dr. Westphal responded that this was not his perspective from listening to Mr. Doe. He disagreed that Mr. Doe showed any ability to engage in abstract thinking, stating that he had acquired some factual knowledge and that what he said was scripted or based on what others, perhaps the prison chaplain, had told him. So all of these things are problems for the court. I recognize that philosophy and empathy are not synonyms. However, in light of these discussions, I find it difficult to understand how Dr. Westphal can continue to maintain that Mr. Doe is a concrete, rigid, literal thinker who is incapable of abstract thought or moral reasoning. To summarize, I find that Mr. Doe has significant deficits as a result of his ASD, particularly in the areas of social communication, the ability to understand the emotions and perspective of others, and the ability to feel empathy. Mr. Doe has no cognitive impairment, which is both a benefit and in some ways a disadvantage. He has been able to use his intellect to compensate for some of his impairments. He's learned methods of interacting. He's able to work out abstract concepts and analyze moral problems. However, these are not natural to him. He has to work at it. Questions that maybe others are answered by the vast majority of people innately or intuitively may also be answered correctly by Mr. Doe, but only after the application of intellect and the process of logical reasoning. Although Mr. Doe clearly has impairments in these social constructs, he is not incapable of abstract thought, and he does have some theory of mind. He tends to be a literal, concrete thinker, but he is also capable of abstract thought and introspection. It takes him much longer to work out these problems than would be the case for most people. Mr. Doe will experience the most severe impacts of his disorder in situations where he is required to respond immediately to a stimulus or make a snap judgment. Given time, he does much better. He has been able to navigate his way through high school, college, getting into and out of the military, and getting an excellent job in his chosen profession. He has friends, but not many. He perpetually feels like an outsider who does not fit in. The downside of his intellect is that he fully understands what he's missing and has lost hope that he will acquire the social life to which he aspires. He feels lonely, believes himself to be a failure in life, and feels hopeless to change it. And I don't think his life is likely to get any better at this point. Quite the opposite. I think he's going to be in for a bit of a rough time in the next little while, as this judgment sort of illustrates. Yeah, so there's a whole lot there, but we can see the court sort of going through this. This is not a snap judgment situation. The allegations are that he spent several weeks at least planning all this out. So when the court is finding that he can do well with planning time, that doesn't bode well for him in terms of the NCR finding. Statements to the police. Mr. Doe made a fully voluntary statement to Detective Rob Thomas on the night of the attack, starting at 10:46 p.m. He talked to Detective Thomas about being a heterosexual male who would be interested in having sex with women, but that women were not interested in him. He said that he was a bit upset that women would choose to date obnoxious males instead of a gentleman like himself. Yeah, I don't think anybody that you hit up really would describe you as a gentleman, and none of them are going to be filled with regret with having missed that opportunity. He described having discussions with like-minded males on internet sites such as 4chan and Forever Alone, and acknowledged embracing the incel, involuntary celibate, movement. He gave an example of an incident at a Halloween party in 2013 when he tried to initiate a discussion with girls, but they laughed at him and hung onto the arms of big guys. He described being very angry about this. He claimed that other guys on the internet expressed the same feelings, but they were too cowardly to act on their anger. He said that he had become radicalized after Elliot Rodger committed an act of mass murder on May 23, 2014, significantly raising the movement's profile. He also admired another incel murderer, Chris Harper Mercer, and claimed to have had discussions with both of these killers prior to their deaths. Mr. Doe said that what Rodger had done was to start a beta uprising against the Chads and Stacys, referring to obnoxious males and the women who choose to date them instead of gentlemen. He said that since June 2014, he'd been thinking it was time he stood up to the Chads and Stacys by taking action, rather than festering in his own sadness. He told Detective Thomas that a day before his attack, he posted an anonymous message on 4chan stating that the beta uprising was starting and encouraging others to follow suit. He said lots of posts were received encouraging this move. However, he said he did not otherwise tell anybody what he was planning to do. In the days leading up to the attack, he described being preoccupied with thoughts about it, saying that he thought about it 80% of the time. I'm going to skip over his description of the details here. At the end of the interview, when Detective Thomas asked Mr. Doe how he felt about the fact that 10 people had died and 15 people were seriously injured, note that that was actually 16 people, but Detective Thomas didn't know that at the time. And Mr. Doe replied in a matter-of-fact tone of voice, "I feel like I accomplished my mission." The reason Mr. Doe gave to Detective Thomas for carrying out this attack is consistent with the message he posted on Facebook during the course of the incident. Private Recruit Doe Infantry 00010, wishing to speak to Sergeant 4chan, please. And then C, lots of numbers. The Incel Rebellion has already begun. We will overthrow all the Chads and Stacys. All hail the Supreme Gentleman, Elliot Rodger. This was a highly skilled interview. Detective Thomas ensured that Mr. Doe was comfortable and fully cognizant of his rights. That's not entirely true. There was some discomfort that appeared to be applied strategically. I mean, amongst other things, we can note that Detective Thomas had arms on his chair. Mr. Doe did not. There's various other sorts of little subtle ways they can make people uncomfortable that don't really look like that's what they're doing. He did not pressure Mr. Doe to answer and did not show any signs of disapproval, except at the end of the interview on the issue of not telling the truth. I'm not sure about the not pressuring Mr. Doe to answer. Again, Detective Thomas is a very skilled interviewer, and there are many techniques where they can apply pressure to answer questions without seeming to apply, pressure. They don't need to use a rubber hose. I covered all that in more detail in the other videos, so go watch those if you want to sort of see what's going on there. Throughout the interview, Mr. Doe showed a flat affect and spoke almost in a monotone, showing no emotion. His demeanor did not seem to change, no matter what he was talking about. However, one aspect of what Mr. Doe told Detective Thomas was a definite lie. He gave a very detailed account about how he got from his home to the rental company to pick up the van, including specific buses, where he changed, how long it took, and things of the like. He was quite convincing. At the end of the interview, when Detective Thomas challenged whether this was true, Mr. Doe said that it was. Detective Thomas then told him he knew it was not true because the police had already interviewed his father, who told him that he had dropped his son off at the nearby Starbucks. At that point, Mr. Doe admitted that he had lied, stating that he was concerned they would think his father was an accomplice. I can see no detectable difference between the way Mr. Doe gave the false account of his trip to the rental company and anything else he said. It might be hard to identify lying with somebody with a straight flat affect who doesn't show much emotion. Subsequently, Mr. Doe told many of the assessors that much of what he told the police was a lie. For example, the incident Mr. Doe described at the Halloween party in 2013 is almost certainly untrue. His father stated that his son never attended such a party in 2013, or ever. It appears that this detail was lifted directly out of Elliot Rodgers' manifesto. It is also highly unlikely that Mr. Doe was ever in direct contact with either Elliot Rodger or Chris Harper Mercer. Again, there's no discernible difference in tone and affect between when Mr. Doe was telling the truth about matters that have been verified, for example, when and how he reserved the rental van, and when he was telling a lie. This makes it difficult to determine what was actually going on in his head at any given time. So at this point, the court reviews a large number of statements made to different experts. I'm only going to cover some of these because they're fairly repetitive. There's a lot of overlap in them, and just for time. But if you want to read them all, they'll be in the case, which I'll link below. Dr. Chohan interviewed Mr. Doe on several occasions in September 2018. Her interviews were more about the aspects of autism that affected Mr. Doe, but she did get some information from him about the attack itself and the events leading up to it. Dr. Chohan's, and I hope I'm pronouncing that right, I suspect I'm not, opinion is that Mr. Doe carried out these attacks for the public notoriety it would bring him. She noted that even in his school years, Mr. Doe preferred to receive negative attention rather than no attention at all. For example, saying and doing goofy things in order to get people to laugh at him. He told her that he had an intense fear since middle school of being rejected by girls and believing they were laughing at him behind his back. He described one incident in college in which he approached a woman he did not know and attempted to engage her in conversation with a view to dating her. She politely declined, and he felt rejected. He did not mention anything to her about the Halloween party in 2013. Mr. Doe told Dr. Chohan that when he was in high school and feeling down about being bullied, he started to fantasize about school shootings and other mass murders. He searched internet sites for information about mass murder and came across Elliot Rodger and his manifesto. He identified closely to Elliot Rodger in a manner Dr. Chohan thought was unusual, in that he saw only the similarities between them and none of the differences. He told her that by December 2017, he was obsessed about Elliot Rodger and was reading and thinking about him daily. He described great feelings of loneliness in college as he watched other students interacting and felt socially isolated. He said he began to fantasize about shooting people as Elliot Rodger had done for the shock value of people learning what he had done. However, having concluded it would be too difficult to get a gun, he decided to use a van instead. He talked about his brief time in the military, but did not say anything about having joined up to learn about weapons, contrary to what he said in his police interview. He said he had failed some courses at college and saw the military as an easy way to get a job. As for the timing of the attack, he told Dr. Chon he wanted to finish all the requirements for his degree first, and that he expected to die as a result of the attack he was planning. Dr. Chon was of the view that Mr. Doe was not otherwise suicidal. He simply saw being killed by the police as part of his overall plan. Dr. Chon saw Mr. Doe's fixation on Elliot Rodger as being odd. She said the manifesto oozes with anger, but she saw no anger emanating from Mr. Doe. He did not appear to blame others for his problems, but rather saw himself as being unable to accomplish things. He believed he would fail at his job before he had even started the job. Dr. Chon testified that Mr. Doe showed no emotion when talking about the attack. He had no remorse. He told her he thought the attack was worth it. He realized that he was simply hitting random people as he drove down the sidewalk, and said he had been wishing for more female victims and had hoped that there would be more young, attractive females hit. When asked how he feels about it now, he said he was happy because when people go on Google, his name will come up and they will see what he did. Now, to me, this is a little inconsistent. She says she sees no anger from Mr. Doe here, but that to me sounds like he's angry if he's saying that he wished he'd hit more women. Also, just as a note, in a few years, very few people are going to really remember who this guy is. He's going to sink once again into obscurity, and so this is not really a great way to get fame. It's nobody's going to remember him in a few years. Dr. Chon believed that in the period of time prior to the attack, Mr. Doe had become hyperfixated on writings about mass killings and indoctrinated with the viewpoint of Elliot Rodger without ever seeing information from other people who might have different views. Although Mr. Doe talked quite a bit about Elliot Rodger, Dr. Chon did not question him in any detail about the incel movement. She was not aware that, in August 2018, Mr. Doe had told her colleague, Dr. Bradford, that he made up his attraction to the incel movement and obsession with Elliot Rodger. So skipping ahead, again, there's a lot of overlap between these. Mr. Doe told Dr. Wright that he was hoping to kill 100 people in the 2018 attack, as that would be a world record. Not actually correct, but doesn't much matter. He said his preference was to kill women, but the overarching goal was to kill as many people as possible. Dr. Wright testified that Mr. Doe reported this in a matter-of-fact manner, not joking in any way. When Dr. Wright asked him if he now thinks it was all worth it, Mr. Doe said that he was happy and excited that people were talking about him and was satisfied with a kill count of 10. Dr. Wright asked him how his thoughts had transitioned from killing peers he disliked to wanting to target women. Mr. Doe responded that in 2018 he had become more lonely and was convinced he would never have a relationship with a woman. He was also nervous that he would get fired from his job. He thought it would be better to die having accomplished this one significant thing and be remembered for it as an achievement for all eternity, as opposed to simply dying in obscurity as a failure. Mr. Doe described to Dr. Wright the actual process of the killings in the same manner as he did in the other interviews. Dr. Wright noted that Mr. Doe, unlike other mass killers, appeared to be lacking any type of anger or rage. He was not a narcissist, blaming others for his problems. Instead, he saw himself as having failed at many things because of his own shortcomings. As with all other assessors, Dr. Westphal was struck by the complete lack of emotion displayed by Mr. Doe when describing these horrific actions. Dr. Westphal testified that Mr. Doe could have been describing a shopping list. Dr. Westphal also agreed with the other experts who concluded that the suicidal aspect of this attack was merely part of the overall mission. Apart from that, Mr. Doe had no wish to kill himself. Consistent with his story to the other assessors, Mr. Doe told Dr. Westphal that the reason he told the police and posted on Facebook that this was an incel rebellion attack was to generate more attention for himself. Dr. Westphal concluded that the incel motivation was just a veneer and not the real motivation behind the attack. Of course, not the real motivation behind the attack, and yet he's wanting to have hit more women, so it's really unclear what's going on here. Mr. Doe also told Dr. Westphal about his feelings of loneliness and his anxiety about not succeeding at his new job. He also described his fascination with websites dedicated to mass murder and other hateful topics, and talked about attaining a high kill count in order to get on the list of high achievers recognized by one of those websites. If you're the person running the website that he was such a fan of, now might be a little bit of a time to think about what you're doing and what you're putting out into the universe. Dr. Westphal opined that Mr. Doe's professed identification with the incel movement or motivation was not real. Mr. Doe told him that he used the Elliot Rodger information in his statement to the police to spice up the narrative. Dr. Westphal did believe, however, that Mr. Doe was obsessed with Elliot Rodger and his manifesto. Dr. Westphal also accepted that other motivations described by Mr. Doe were real. For example, loneliness and isolation, job anxiety, and the desire for notoriety. He testified that at one point, Mr. Doe attempted to put percentages on his motivations as follows. 40% identification with Elliot Rodger and his feeling of loneliness, 25% desire to carry out a mass killing, 20% notoriety and fame, 15% anxiety about his job. But in one that I skipped over, he had given different percentages at other times. Dr. Westphal testified that he believes Mr. Doe himself is not really sure why he carried out this attack. That's probably a fair statement. Mr. Doe told Dr. Westphal that if he had the opportunity to do this all over again, he would be more specific in targeting women between the ages of 18 and 30. He said this would be more consistent with what he told the police and posted on Facebook, and the basis upon which he was trying to get notoriety. Asked if he would do it again if he got out of jail, he replied that he was not sure, but that it would certainly pop into his head. He said that if he did get the chance to do it again, the opportunity to improve his kill count score on the website he frequented would be a motivator. So, just looking into the future, there is a high possibility that they run his periods of parole ineligibility consecutively rather than all together, which would mean that if that happens, he would basically never be eligible for parole until long after he's dead. But let's assume that he is still alive at a point where he becomes eligible to apply for parole. Do you think these statements are going to end up in front of a parole board in that case? I do. And do you think that a parole board is going to think real long and hard about that kind of thing? Yep. I can't see a parole board ever wanting to stamp an approved stamp on Mr. Minassian getting out of jail. The risks are too high. His statements about his future plans, real particular, real specific. I just can't see it. My very, very strong expectation is that unless somehow he's successful in appealing this decision, which I don't think is likely, but if he is successful in appealing this decision, or if he's not successful in appealing this decision, my expectation is that he dies in a jail cell. So that sort of writing the postscript, and after having sort of, he at some point indicated that he didn't want to rot in obscurity. That was part that I skipped over here, and maybe I shouldn't have, but that's what's going to happen. Anyway. Analysis. It is almost impossible to tell when Mr. Doe is lying and when he is telling the truth. Working out his exact motivation for this attack is likewise close to impossible. However, there are some common threads from which it is at least possible to identify some of the factors and determine which are the most significant. I placed considerable reliance on the expert psychiatrists and psychologists who interviewed Mr. Doe. Ultimately, it is my task to decide what the facts are, but I am greatly assisted in that task by the many doctors who spent many hours talking to Mr. Doe. They found him to be forthcoming and cooperative, and they thought he was being truthful with them. Some of the testing they did was designed to detect malingering, so faking a condition or faking an illness, and they never detected any. Of course, that does not mean everything Mr. Doe said was true, nor does it follow that because he said the same thing numerous times, it is more likely to be true. He has an excellent memory and above-average intelligence. He is capable of maintaining a convincing lie over time. Nevertheless, I am inclined to accept the assessment of all the experts that Mr. Doe did lie to the police about much of the incel motivation he talked about, and that the incel movement was not in fact a primary driving force behind the attack. I note as well that Mr. Doe's father commented that when his son was talking to Detective Thomas, he was using the tone of voice and demeanor that he would use when doing a presentation, as if he was acting a part. I am confident that Mr. Doe started fantasizing about school shootings and mass murders from the time he was in high school. He has a wealth of knowledge about these kinds of killings and the people who carry them out. From the details he knows, it is also clear that he has spent considerable time on chat rooms and other internet sites devoted to mass murders and incel followers. He is clearly fascinated by, and to a degree obsessed with, Elliot Rodger and his manifesto. However, Mr. Doe shows none of the venom typical of incel followers. Although frustrated and disappointed that women did not appear to be interested in him, he has never expressed hatred or even anger towards women, not even in his initial statement to the police. Likewise, he did not at the time, and has not since, shown any pleasure or sense of satisfaction to have killed or injured women, apart from the notoriety it has brought to him. Accordingly, I agree with the assessors that Mr. Doe's story to the police about the attack being an incel rebellion was a lie. I am also persuaded by the unanimous conclusion of the experts that Mr. Doe did not start out with a decision to commit suicide and then select a way to do it in a spectacular or memorable fashion. Rather, he decided to do the mass killing, and dying in that process was merely part of the overall plan. What, then, was his motivation? I am drawn to the conclusion that there was no one clear motivator. Mr. Doe was profoundly lonely and felt hopeless. He saw nothing in his future but failure, both in social relationships and work. He wanted to be seen. He wanted to be known and talked about. He saw no way to accomplish that except through a spectacular act of violence. He'd been musing about mass murder for years to varying degrees. Convinced that he was about to fail in his first real job and live a life of obscurity and dependence, he decided instead to achieve fame and notoriety, even if it meant dying in the process. I am sure that resentment towards women who were never interested in him was a factor in this attack, but not the driving force. Instead, as he told every assessor, he piggybacked on the incel movement to ratchet up his own notoriety. Why did he do it? There's a long answer. There were multiple factors at play, as I have described above, as well as the impact of his ASD and possibly desensitization as a result of the depraved internet sites he frequented. But there's also a short answer, a bottom line. He did it to become famous. So the next question the court is going to grapple with is, did he know it was wrong? So 1, he appreciated the nature and quality of his act, knew it was murder, and knew it was legally wrong. There is no question that Mr. Doe set out in a planned and deliberate manner to commit multiple murders. There is also no question that he fully appreciated the nature and quality of his act and knew that it would be considered first-degree murder under Canadian law. The following is an excerpt from his statement to the police on the night of his arrest. Question: do you know what first-degree murder is? Answer: it's a premeditated murder and completely intentional and considered to be in what's known as cold blood. Do you understand what premeditated means? Yes, it would mean that someone has planned for that murder in advance. Mr. Doe was fully aware that what he had done constituted first-degree murder and that he would be facing a sentence of imprisonment for life, a fate he planned to avoid by provoking the police into killing him. He knew, at least intellectually, that it was morally wrong. Moreover, Mr. Doe was able to articulate that his actions were morally wrong in that society would consider what he had done to be wrong. When interviewed by Dr. Woodside, he said that most people would consider a mass murderer to be despicable. He said that there would be fringe groups on the internet where people would praise what he had done and might joke about it if they were immature teenagers. However, he stated that he knew at the time that most people would view both mass shootings and his own acts as morally wrong and unjustifiable. Similarly, when interviewed by Drs. Westphal and Alvarez Toro, Mr. Doe spoke clearly about his knowledge of the moral wrongfulness of murder. One particularly illuminating example of this is the following exchange on day 3 of their interviews. Dr. Westphal: so do you think it's fair to say that you understood what you did was wrong? Mr. Doe: yes. Dr. Alvarez Toro: wrong for society, wrong for you, both? It's wrong. It's wrong in the sense that it's immoral. Dr. Alvarez Toro: for you think there are two perspectives, like it was immoral, like you knew society would judge you as that act being immoral, or did you think you shouldn't do this because... Mr. Doe: both. I knew myself it's wrong what I'm doing, regardless of what other people are saying. I knew it was wrong to kill. Why is that? Well, because I've been told by everyone, by family and school or wherever. It's just an ingrained pillar, the ingrained sole rule that killing is wrong. Likewise, in a previous interview with Dr. Westphal, Mr. Doe stated, I know what I did was morally wrong, and extremely devastating, and irreversible. When Dr. Westphal pressed him to say what he meant by wrong in terms of according to what standards, Mr. Doe replied, societal role standards. One of the most important one being that it is extremely wrong to kill people. Dr. Bradford obtained similar information from Mr. Doe. He told Dr. Bradford that to kill is extremely immoral and that his actions would be seen as morally terrible by anybody in the community. If the legal test for morally wrong at the second branch of the Section 16 analysis is mere intellectual knowledge that society would consider the act to be morally wrong, or that the act was something the accused knew he ought not to do, then that would be the end of my inquiry. Mr. Doe's cognitive ability to know right from wrong was unimpaired by his disability. The fact that he had ASD did not mean he did not have the capacity to know that society would consider this to be immoral. On the contrary, he actually knew, at least intellectually, that by society's standards his actions were morally wrong. Indeed, as I concluded above, his primary reason for carrying out the attack in the first place was to attract notoriety, an implicit recognition that people would be horrified by it. However, as I have identified earlier in these reasons, in my view, the test as developed in Uman requires more than the intellectual capacity to know what societal norms are, but also includes a capacity to rationally evaluate what he is doing and to make a rational choice to do it. 3. He had the capacity to rationally evaluate what he was doing and to rationally choose between what was right and what was wrong. I then turn to what I consider to be the pivotal question in this case. Did Mr. Doe, because of his ASD, lack the capacity to exercise a rational choice between carrying out these murders or complying with societal and legal norms that killing is wrong? In other words, was his decision to carry out these acts the result of a rational, reasoned decision, or did he lack the capacity to make such a reasoned decision because of his disability? On this issue, the experts disagree. So, evidence of Dr. John Bradford, who was retained by the defense. Dr. Bradford testified that Mr. Doe does not have any kind of psychotic disorder. That doesn't mean mental disorder, by the way. It's just a psychotic disorder that would cause him to have delusions or that sort of thing. This is an opinion on which all of the experts are unanimous and which I accept. Dr. Bradford found that Mr. Doe had no empathy for his victims at the time or since, and has expressed no remorse for his actions. This is consistent with the findings of every expert who met with Mr. Doe, and I accept it as a fact. Dr. Bradford was careful to distinguish between the lack of empathy seen in a psychopath and the situation of a person with ASD. The psychopath has the capacity to feel empathy and understanding, but simply does not care, preferring to satisfy his own desires without any regard for how his victim might feel. This is distinct from a person with ASD who is often unable, by virtue of that disability, to put himself in the shoes of another and truly understand how they would feel. Dr. Bradford was clear that Mr. Doe is not a psychopath. Again, every expert agrees on this point, and I accept it as a fact. Dr. Bradford also distinguished the kind of fixed delusions held by a person who is psychotic and an overvalued idea or hyperfocus on a particular idea or construct. He saw Mr. Doe as fitting into the latter group in terms of his fascination with Elliot Rodger and mass murders. So not a psychosis, not a delusion. It's this overvalued idea is kind of a neat concept. However, in his opinion, this was not the kind of intensity required to ground a defense under Section 16 of the Criminal Code, because notwithstanding this fascination, Mr. Doe knew that murder was morally wrong. Based on Mr. Doe's answers to his questions about morality and how society would view his actions, it was Dr. Bradford's opinion that, notwithstanding his ASD, Mr. Doe had an understanding of moral reasoning and knew that what he had done would be seen as morally wrong. Having stated that opinion, and in an effort to be as objective as possible, Dr. Bradford went on to state an alternative theory that could result in a finding of NCR. On that theory, Mr. Doe's lack of empathy and deficits in the capacity for moral reasoning, when combined with his hyper-focus on internet sites featuring the incel ideology, Elliot Rodger and other mass murderers, could be seen as rendering him incapable of the kind of moral reasoning required to be held criminally responsible. He opined that the only basis for this finding would be if Mr. Doe was found to be unable to appreciate the wrongfulness of his conduct. Dr. Bradford believed that there was a credible basis for this to be considered, but in the final analysis still remained of the view that Mr. Doe knew what he did was morally wrong and did not meet the requirements for a Section 16 defense. Evidence of Dr. Alexander Westphal, who was retained also by the defense. Significant to his ultimate opinion, Dr. Westphal found that Mr. Doe had a rigid, concrete way of thinking and a theory of mind deficit or mind blindness that interfered with his capacity to understand that others have internal states that differed from his own. He believed that, because of these deficits, Mr. Doe was less able to appreciate the theatrical and exaggerated nature of things he was fascinated with on the internet and took everything literally. Dr. Westphal considered the reasons given by Mr. Doe for having committed these acts. He dismissed the idea that Mr. Doe was motivated by revenge to punish those who had bullied or rejected him in the past. He noted a complete absence of anger or hatred toward these people, and an absence of any history of ever feeling such hatred. The other reasons he considered were the desire for notoriety and anxiety about failing at a job he had not yet started. Dr. Westphal rejected these as being insubstantial reasons to inflict such an enormous amount of pain and to either die or be incarcerated for life as a result. This seems strange to me because this is sort of well known in the literature that there is a sort of pursuit for notoriety in these instances. So I'm not sure why that's being rejected here. He testified that at times Mr. Doe attempted to place percentages on his various stated reasons for carrying out the attack, but said that these numbers mean nothing, and he did not think that Mr. Doe himself understands why he did this. Dr. Westphal testified that the only common element is that none of these reasons provide a satisfactory account for committing this attack. He said that, to him, this meant one thing, which is that he didn't understand the horrific impact of what he was doing. I'll let you decide if you like that reasoning or not. One of the reasons Dr. Westphal rejected the idea that Mr. Doe was motivated by a desire for notoriety was because he saw in the prison records that Mr. Doe had twice turned down requests from journalists to interview him. Dr. Westphal said that he found this to be inconsistent with Mr. Doe's stated desire for media attention. On cross-examination, Dr. Westphal acknowledged that he had never raised this point with Mr. Doe. On April 26, 2018, in response to the first of the media requests for an interview, Mr. Doe wrote on the request form, "At this time, I do not consent because I have not been tried yet." On the second request, 5 days later, he simply wrote, "No." During that same time frame, a note in his prison medical chart indicates that he refused to discuss the details of the material as per his rights. Dr. Westphal agreed that these refusals may have been based on legal advice. In his report, and certainly any lawyer, if you are facing charges like this, is going to tell you, do not talk to the media for the same reasons you don't talk to the police or anyone else, because doing a media interview would be extremely dumb. So in his report, Dr. Westphal concluded that Mr. Doe did not understand the impact and consequences of what he was doing, and although he intellectually knew it was wrong, he did not appreciate the moral wrongfulness of his actions. Dr. Westphal cited 5 reasons why he believed this to be the case. 1. Mr. Doe demonstrated a complete lack of insight as to the impact of his actions on his victims, their families, or his own family. 2. He described his actions as converting life status to death status, which suggests a complete emotional detachment from his actions, as if it was a video game. 3. He showed no emotion during the attack or during his police interview. 4. While planning the attack, he simultaneously planned for the future in prosaic ways, filling out paperwork for his upcoming job, planning to go out with his brother to celebrate graduation, suggesting widening the driveway to accommodate the car he planned to buy. He told his family during a prison visit that he was optimistic about the prospect of going home, and that he believed others would see he had done nothing wrong. Dr. Westphal and his colleagues then concluded their report with the following opinions. In summary, it is our opinion that without ASD, Mr. Doe would not have perpetrated this offense. We conclude that although Mr. Doe understood the wrongfulness of his actions from an intellectual standpoint, he did not understand the wrongfulness of his actions from a moral standpoint. The act was also completely beyond his comprehension given his absence of understanding of emotional nuance, social exchange, and contextual accommodation. He had absolutely no insight into the terrible impact that the act would have on other beings, and did not think about the pain he was bound to cause, nor understand it, even slightly, now. Dr. Westphal placed significant reliance on Mr. Doe's complete lack of empathy for his victims. He described Mr. Doe's thought process as he was mowing down and killing people as being akin to playing a video game, concluding that Mr. Doe was unable to understand the actual impact of his actions on his victims' families, or even his own family. From this, Dr. Westphal drew the conclusion that Mr. Doe did not understand that his actions were morally wrong. He accepted that Mr. Doe knew this was a real-life situation, as he was killing and injuring people, but said he was so detached from it emotionally that it was almost a dissociative quality. Dr. Westphal testified that because Mr. Doe's inability to truly understand the horrific consequences of his actions, he was not capable of making a rational choice. He was adamant in his testimony that Mr. Doe had no understanding of the impact on his victims, their families, or his own family at the time of the attacks, and still does not have any understanding. When cross-examined about the numerous statements Mr. Doe made about the impact on the victims and families, Dr. Westphal stated his belief that this was merely lip service and not true understanding, and that Mr. Doe likely picked up these ideas from other assessors who interviewed him or from other sources, such as pleadings in civil actions, discussions with his own lawyer, or discussions with the prison chaplain. He gave as an example the word devastated, which had been used by Mr. Doe at one point to describe the impact on his own family, and which he suggested was a word Mr. Doe had picked up from someone else. He acknowledged that he had no information on which to base that assumption, and that he was theorizing about it. I have another word that might apply. He also acknowledged that he did not include in his report that Mr. Doe had said that he thought his parents would be devastated by his actions, explaining that he had left it out because he believed Mr. Doe did not understand anything beyond the most minimal insight. Skipping ahead a little bit here, although not referred to in his report, Dr. Westphal conceded in cross-examination that Mr. Doe had an active decision-making process before deciding to carry out the attack, and even after hitting the first group of pedestrians, made a further decision to keep going. Dr. Westphal agreed that prior to the attack, Mr. Doe vacillated about whether he would go through with it. However, Dr. Westphal denied that this was connected in any way to moral reasoning, but rather stemmed solely from his concern that he might chicken out. He also stated that he did not believe that there was ever a point where Mr. Doe was wrestling with his conscience in a moral sense. He said that Mr. Doe had set himself on a dare and then experienced some ambivalence only about whether he had the guts to go forward. Dr. Westphal was referred to one of his interviews in which Mr. Doe referred to the ingrained pillar, the sole ingrained rule that killing is wrong. Dr. Alvarez Toro then asked him how he was able to go ahead thinking that this was wrong and then commit these acts. Mr. Doe responded as follows. Mr. Doe, just ignoring all the other thoughts and continuously think, I really want to do this, I'm going to do this, I'm going to do this. Dr. Westphal, and willfully ignoring those other thoughts or feeling compelled to do them regardless of those other thoughts? It was a combination. It was the fact that I wanted to do it, but then it was willfully ignoring it and amplifying feeling compelled to do it. One thing I sort of note here is that that sort of question is itself kind of suggestive, but, Mr. Doe is saying, I am willfully ignoring this. Well, willfully ignoring something is kind of ties into the concept of willful blindness that the courts, it's basically not something the courts typically accept. On cross-examination, Dr. Westphal remained of the opinion that this did not constitute rational decision-making or moral reasoning, but rather was only a concern that he would not have the courage to carry out the planned attack. In that same interview on January 17, 2020, Mr. Doe told the doctors that he was hoping that everything would fall through, there would be no attack, and he would go on with his job and try that out. He said this would be the best-case scenario, that perhaps the van would just not be available and he would not be able to proceed. Dr. Westphal again testified that this was not an example of moral reasoning, but rather an example of how Mr. Doe saw only two options: carry out the attack and either die in the process or be incarcerated for the rest of his life, or not proceed with the attack and have to try the job and likely fail. Dr. Westphal conceded in cross-examination that the basis for his conclusion that Mr. Doe did not understand what he was doing was the fact that he did not provide anything that Dr. Westphal considered to be a good reason for doing it. He said that if Mr. Doe was able to comprehend the impact, he would not be able to describe it in the flat, unemotional way that he does. Now, good reason for doing something is very rarely actually needed for people to commit murders. People commit murders all the time for reasons that are extremely weak. People have been killed over incredibly small amounts of money. People have been killed over, looking at somebody wrong or this sort of thing. So, I don't really know how much I think a good reason is necessary, or that the absence of a good reason necessarily means that somebody must be NCR. So now let's look at the evidence of Dr. Scott Wood's side. Dr. Woodside testified that he sees Mr. Doe as a mass murderer who happens to have ASD rather than a person whose ASD caused him to commit this crime. Consistent with all of the experts, Dr. Woodside testified that Mr. Doe clearly appreciated the nature and quality of his actions. He was also of the opinion that Mr. Doe also knew that most people in the community would see his actions as despicable and morally wrong. Dr. Woodside saw this as a fundamental part of Mr. Doe's reason for committing the crimes. He was seeking notoriety, to be known for a big thing, and committing a mass murder was a calculated move to do something that people believe is the worst thing you could do. He testified that Mr. Doe certainly knew right from wrong and was a rational thinker. However, Dr. Woodside, like all of the assessors, found that Mr. Doe was lacking in empathy. Dr. Woodside therefore saw the central question raised as being whether Mr. Doe could rationally engage in moral reasoning without being capable of feeling empathy. Dr. Westphal accepted that there would be some degree of desensitization by virtue of Mr. Doe's many years of fascination with mass murder, which has the effect of dehumanizing the victims. However, notwithstanding these fixed areas of interest, he was able to engage in other activities such as finishing college, engaging in a successful job search, and playing video games. Although anybody can play a video game, that's I don't know that there's a whole lot to that one, as well as some social interactions with his brother and friends. He did not believe Mr. Doe to be delusional, nor did he see any evidence that he was in a dissociative state. Dr. Westphal did not agree that Mr. Doe was incapable of moral reasoning. He recognized that Mr. Doe had deficits and that it was hard for him to empathize or put himself in someone else's shoes. He opined that Mr. Doe is capable of reasoning through moral issues, it just takes him longer to do it. Although he may not innately understand that the other person's perspective or feelings, he's able to use his intellect to reason it through, provided he has enough time to do so. Dr. Woodside saw Mr. Doe's moral reasoning deficits as having more of an impact in a situation where he might be called upon to make a sudden decision on the spur of the moment. However, he'd been thinking about mass murder for years and had been planning the specifics of this particular attack for nearly a month. He described Mr. Doe as engaging in an adaptive behavior, whereby he puts aside thinking about these acts being wrong and about the impact they would have because it was something he really wanted to do. Dr. Woodside noted that this is a common strategy that people use every day. When they want something badly and they know there are bad aspects, they compartmentalize and push out the thoughts that constrain them or would prevent them from doing what they want. He also compared it to the kind of thinking engaged in by perpetrators of other crimes. For example, pedophiles who know what they are doing is wrong and harmful, but yet continue to abuse children because it is something they strongly want to do. Dr. Woodside cited specific examples of Mr. Doe using this kind of reasoning. He said that Mr. Doe used the ideology of the incel movement to rev himself up into undertaking mass murder, even while recognizing that he was not himself a misogynist and that he did not have strong feelings of anger or rage towards women. He told Dr. Woodside that he saw the incel ideology as a way of forcing himself into the mindset so that he wouldn't chicken out. He said, "But I also wanted to do it. I was trying to push out all thoughts of trying to talk myself out of it." Mr. Doe also told Dr. Woodside that he knew his parents would be shocked when they found out what he had done, but that he put those thoughts aside because I really wanted to go through with it. Dr. Woodside also rejected the notion that the highest order of moral reasoning is required and suggested that very few people engage in that level of introspection in their everyday lives. He noted that Mr. Doe was willing to give up his own life, not just the lives of his victims, to achieve his objective of notoriety. He saw Mr. Doe as being without hope for his future. Mr. Doe had considerable insight into his social deficits and believed that he would never marry or have a family and would never be successful in life, which he's now guaranteed. He was overwhelmed with feelings of loneliness and failure. He was anxious about what he saw to be his inevitable failure at the new job. He believed it would be better to leave his mark by becoming famous, even if for negative reasons, which he saw as being better than rotting in obscurity. Dr. Woodside testified that Mr. Doe might have had other reasons as well, but he saw no basis for discounting the reasons Mr. Doe did provide. Further, he disagreed with Dr. Westphal's view that these reasons should be rejected because they did not provide an adequate explanation for the crime. Dr. Woodside pointed out that there is no such thing as a good reason to commit mass murder, and that the reasons Mr. Doe provided are as easily understandable as other reasons Dr. Westphal would have accepted. For example, the incel ideology or feelings of rage and hatred. I find this to be fairly persuasive here. And I mean, part of that is that it's being summarized by the justice who likes clearly Dr. Woodside's view better than Dr. Westfall's. But this to me makes a lot more sense. Even you don't have to go so far as, people who are abusing children, even people who are engaging in shoplifting. There are some people who are shoplifting because they're, desperately in need. But you also get people who just, who aren't, who might be doing it for a thrill or the like. And they are very often sort of able to push out all the reasons not to, so that they can do the thing they want to do, or do the thing that's exciting, or whatever. So I find that this rings true with my experience. And yeah, so this to me seems to make a lot more sense. And, the bit about, there's no such thing as a good reason to commit mass murder. That's almost a mic drop moment right there. I think that's really the winning statement in this particular battle of experts. Yeah, mic drop. All right, folks, we're into the home stretch. This is the analysis section. I come finally to the crux of this case. Whether at the time Mr. Doe carried out this attack, he was, as a result of his ASD, incapable of knowing that what he was doing was morally wrong. This is a question of mixed fact and law, and it is a question for me to answer. Now, mixed fact and law is that both facts and law are involved. Typically, what this means is that the court has to determine what the facts are and apply the law to those facts in order to get the ultimate answer. So, in this case, they've got the facts of what's going on in his head, and then does the things going on in his head meet the legal tests? That's sort of how that works. Given the subject matter, it is of course relevant, indeed necessary, to take into account the expert evidence of the various psychiatrists and psychologists who have testified and or provided written reports to the court. Their contribution has been extremely helpful. However, in the final analysis, it is for me to decide whether the defense has established Mr. Doe's incapacity on a balance of probabilities. As I've already stated above in the legal analysis portion of my reasons, I consider I am bound by the Supreme Court of Canada's decision in Uman, and that, therefore, my analysis on this question extends beyond whether Mr. Doe knew that by societal standards his actions were morally wrong. Before I can hold Mr. Doe criminally responsible for his acts, I must consider whether his disability deprived him of the capacity to make a rational evaluation of the situation and make a rational choice to carry out the attack. If the sole question before me was whether Mr. Doe intellectually knew that his acts would be perceived in society as morally wrong, my answer would be clear-cut. Mr. Doe has repeatedly told everyone he spoke to that he knew his actions constituted first-degree murder, and also that he knew what he had done would be condemned by everyone in society, with the possible exception of some fringe groups on the internet. He described the social norm that killing is wrong as an ingrained pillar that he had learned from his family and at school. He variously referred to his attack as devastating, despicable, shocking, morally terrible, a horrible thing, and irredeemable. He said that he knew these acts were morally wrong. I do not agree with the defense submission or the opinion of Dr. Westfall that these were concepts or expressions that Mr. Doe picked up from others since his incarceration. Mr. Doe himself explained that this was something that was taught to him by his parents and others, and something he has always known to be an ingrained pillar of society. There is no question that on an intellectual level, he knew that murder was morally wrong. If that is the extent of the test, then the defense clearly fails. However, as I've said, in my view, the test as articulated in Uman requires more than the intellectual capacity to recognize that society would see these acts as immoral. There must, in addition, be an exercise of a rational choice, recognizing the moral wrongfulness of the act and nevertheless freely choosing to proceed with it. I must therefore consider the impact of ASD on Mr. Doe and determine whether it rendered him incapable of rationally evaluating and rationally deciding on a course of action. It must be recognized as well that the court in Uman did not depart from previous case law that has consistently recognized the difference Parliament intended by using the word appreciating in the first branch of the Section 16 test and knowing in the second branch. The addition of the requirement for rational decision-making does not import into the second branch the degree of insight and understanding that would be required to constitute appreciating moral wrongfulness. Knowing is a lower standard than appreciating. There are two important points to bear in mind from the outset. 1. This is not a but-for test resolvable by merely showing that, but for his ASD, Mr. Doe would not have committed these acts. 2. Rational in this situation refers to the exercise of free will and decision-making, and not to the rationality or rightness of the conduct undertaken, in this case mass murder, it being recognized that killing 10 people and injuring 16 can never be said to be a rational decision in many senses of that word. So the but-for test here is sort of a causation thing to determine if something caused something else. The question is, would it have happened but for this other thing? So the but-for test is kind of used to determine fault often in, for instance, negligence cases. Although I'm not a civil lawyer, but I'm just thinking back to my torts class. So, but for somebody taking some action, would this consequence have occurred? Because if it would have occurred anyway, then that first thing isn't likely to be a cause. So they're saying that simply because ASD might have been sort of a necessary precondition for this, doesn't mean that he's met the NCR test. It's something more than that. The only expert witness supporting a Section 16 defense for Mr. Doe is Dr. Westphal, so I'll deal with his evidence first. I did not find Dr. Westphal to be a reliable witness. Nobody who has listened this far should be surprised because the justice has had comments about Dr. Westphal all the way through. He is American trained and practices there. That does not disqualify him from testifying as an expert in a trial in Canada, but in this case, he deliberately refrained from educating himself on the Canadian test for the NCR defense. Now, I remember when Dr. Westphal was indicated that it was indicated that he was going to be an expert, there was some controversy about, they are bringing in this American expert. Inherently, there's nothing wrong with that. The U.S. has many experts, and, if I were in need of certain expertise, there might be nowhere else to go. The U.S., for instance, if you're looking for firearms expertise, some of them are, on certain specific areas, you might have to go to the U.S. Some psychology things, the people who are the founders of an idea might be in the U.S. So the fact that he's from the States isn't in and of itself a big deal, but refrain from educating himself on the Canadian test for the NCR defense? I mean, that's kind of what he's there for, right? So let's see what the court says about this. He justified this by explaining that his job is to provide psychiatric knowledge to legal aspects, not to opine on the legal consequences. I have no difficulty with the second part of that explanation. His opinion on the legal consequences is irrelevant. However, with respect to the first part of his explanation, it would certainly be more helpful if he directed his psychiatric knowledge to the legal aspects at issue, which would require at least some basic understanding of what those legal issues are. Having failed to inform himself on the Canadian test, he proceeded to direct his evidence throughout on whether Mr. Doe truly understood the moral wrongfulness of his actions and whether he fully appreciated the consequences of those acts, which is not the Canadian test. That does not make his testimony irrelevant, but it does make his evidence more difficult to apply. Justice is not terribly thrilled with that choice. The second difficulty with Dr. Westphal was his intractability. He did not appear to me to understand that his role as an expert witness was to be impartial and fair in his assessment of the evidence. He referred only to information that supported his conclusions, ignoring anything to the contrary. There were significant aspects of the information he gathered in the course of his assessments that never appeared in his report and were directly contradictory to the opinions expressed in the report. This could have had dangerous implications for the search for truth, because in the first instance, he also did not disclose his notes or the videotapes of his interviews, all of which were only obtained at the 11th hour because I ordered them to be produced. In the end, I am satisfied that the issues had a fair airing. However, it is troubling to me that this was necessary. There is no problem with an expert giving an opinion that is different from what an accused said to him, but in a fair report, I would expect to see both sides of the evidence and then a reasoned opinion as to why the information offered by the accused was not accepted. Regrettably, that did not happen here. When confronted in cross-examination with information contradictory to his report, Dr. Westphal was adamant, perhaps even rigid, in defending the language used in his report. Further, his evidence was rambling and often not responsive to the questions asked, particularly in cross-examination. Once again, an expert witness is not in the role of, like, defense counsel. As defense counsel, I argue for my client. That is my job, is I am, specifically arguing for my client. But an expert, even an expert I call, like even an expert that, I'm paying, has to be providing fair and balanced information. They have to indicate that, the good sides of their argument and the bad. And the court is not happy with what happened here. Frequently, Dr. Westphal spoke only in extremes, without nuance. For example, he testified that Mr. Doe did not have any ability to see things from his parents' perspective, or to understand the impact of his actions on them, despite being taken pointedly to things Mr. Doe told him about how he thought his parents had been affected. For example, that they would have been shocked, devastated, felt guilty, asked themselves what they'd done wrong, etc. One of the 5 reasons advanced by Dr. Westphal for finding that Mr. Doe did not appreciate the moral wrongfulness of his actions was the fact that he had told his parents during a prison visit that he was optimistic about the prospect of going home and that he believed others would see he had done nothing wrong. This information was provided to Dr. Westphal's team by Mr. Doe's parents. Mr. Doe's father was called by the defense as a witness at trial. The Crown objected to the admissibility of the statement by Mr. Doe being adduced through his father, because, of course, they'd want to get Mr. Doe, or Mr. Minassian in this case, up on the stand, because this Crown, from what we can see just from the reasons here, is a very skilled cross-examiner, is what I can read sort of between the lines. And I suspect that they would have torn him to bits, which is why, you don't want to put your client up on the stand if you can avoid it usually, and especially not if he's about to get, I can't see a way that would have worked out well. Defense was quite sensible, I think, in not wanting to call Mr. Minassian. But I ruled the evidence could be adduced, subject to review at the end of the trial, as to what inferences could be drawn from it. I accept the evidence of Mr. Doe's father that this is what his son said to him. I do not accept that Mr. Doe actually believed either part of this statement. He knew he would not be going home soon. He made a number of statements to his assessors, including to Dr. Westphal, about the fact he believed he would soon be in prison for the rest of his life. Quite sensibly. I think that's correct. He also made numerous statements about knowing that his actions would be seen by society as morally wrong. It is possible Mr. Doe was simply lying to his parents and hiding the truth from them, as he had done since his early teens. For example, fantasizing about mass murders, his obsession with Elliot Rodger, failing courses at college, his plans to join the military, and planning these attacks. Alternatively, he might have said these things in an attempt to allay their concerns for his welfare, thereby demonstrating some degree of empathy. However, regardless of the reason, I find that Mr. Doe was not being truthful in this statement. It is troubling that Dr. Westphal fastened on this one statement as a foundation for his opinion, given that it is totally inconsistent with everything else Mr. Doe said to everybody. In the hours and hours of interviews with the assessors, Mr. Doe never once said that people would know he had done nothing wrong, or that he expected to be released from prison. Indeed, he told everybody else, including Dr. Westphal, the opposite. Not only did Dr. Westphal seize on this one example as evidence of Mr. Doe not understanding his actions were morally wrong, he neglected to ask Mr. Doe about it, and he left all of the other statements out of his report, apart from one passing reference at page 26 of the report. Another difficulty with Dr. Westphal's evidence is that, for him, almost everything hinged on Mr. Doe's lack of empathy for his victims and their families. He examined all of the reasons Mr. Doe had advanced for wanting to commit these acts and rejected them all as not being sufficient justification to carry out an act so horrific. He coupled that with Mr. Doe's lack of remorse and concluded that the only explanation possible was that Mr. Doe simply did not get it, that he did not really understand the impact of his actions, even though he could articulate what those impacts were. I find this logic to be circular. None of the other reasons provided make sense. Therefore, what he said about understanding moral wrongfulness must be rejected on the theory that if he did truly understand, he could not have done it. I'm not sure what explanation would have sufficed for Dr. Westphal in the face of Mr. Doe's lack of empathy for his victims. Would it be an acceptable reason to carry out these acts if Mr. Doe expressed anger or hatred towards women? Is that a more sensible reason than wanting the notoriety and not caring if you die in the process? All of the experts who testified were clear that Mr. Doe is not a psychopath. He is lacking in empathy, but the clear consensus is that this is because of his ASD. In my view, this does not change the analysis with respect to Section 16 of the Criminal Code. Every one of us has or lacks empathy to various degrees. The same is true of people who commit crimes, whether it be fraudsters, drug dealers, rapists, child abusers, or murderers. Many of them may lack empathy altogether. However, that does not create a defense under Section 16 of the Criminal Code. The question is not whether they took into account the impact on their victim, but rather whether they knew what they were doing was wrong and proceeded to do it anyway. A lack of empathy does not render somebody incapable of knowing right from wrong or of making a reasoned, rational choice. Another difficulty with Dr. Westfall's evidence is that he fails to appreciate that a lack of empathy for victims is not sufficient to ground a Section 16 defense under Canadian law. If it were, not many criminals would ever be convicted of anything. As Dr. Wright noted in his testimony, empathy is not a component of an NCR assessment because it is a different thing entirely from knowing whether something is wrong. He testified that a person could have a lot of empathy for the victim and still have an NCR defense, and likewise could have an NCR defense without any empathy whatsoever. They are simply different concepts. So this is, again, important because the courts very much want to get away from this notion of just because you don't care about somebody that it's okay to kill them. That's not the law, and the court is going to make sure that no door towards that path is ever opened. So that door is slammed shut here, as in every other case on this topic. All of the experts, including Dr. Westfall, were also clear that Mr. Doe does not have a psychotic disorder of the type typically seen in NCR cases, nor did he suffer from delusions. Dr. Westfall at one point described Mr. Doe's degree of disability as being almost like a psychosis, and at another point referred to his use of internet sites as being almost a dissociative state. Without agreeing that Mr. Doe's disability ever did approach that level, suffice to say he was never in a psychotic or dissociative state. The only disorder that could possibly ground a defense under Section 16 would be his ASD. Dr. Westfall also pointed to Mr. Doe's reference to converting life status to death status and his lack of emotion during his attack, stating that it was as if he was playing a video game. However, there was no point in time where Mr. Doe experienced a break with reality where he actually believed he was playing a video game. He always knew that these were real people and he was attempting to kill them. The fact that he did so without showing emotion may well be attributable to his ASD, but that does not mean he did so without a rational mind incapable of making choices. The court here is kind of criticizing how the expert talks about it being almost like a psychosis, where a psychosis would have been really helpful for establishing an NCR, or almost a dissociative state. Same problem. And, as if he was playing a video game. Court saying, like, none of the things that are being hinted at here are actually true or actually the case. So there's some criticism there, I feel, sort of under the surface. I turned then to the testimony of Dr. Bradford, who was also a witness for the defense. As I noted above, Dr. Bradford's opinion is that Mr. Doe had the capacity to know his acts were morally wrong, and he does not fit within the conventional parameters of the NCR defense. However, Dr. Bradford went on to state that there could be a credible basis for a defense based on Mr. Doe's deficits in cognitive empathy, the ability to perspective take or to put himself into the shoes of another person, combined with his hyper-focus on internet sites dealing with mass murder and Elliot Rodger. I agree with Dr. Bradford that if there is a defense available, these would be the areas of focus. I also agree with Dr. Bradford, and indeed all of the experts, that Mr. Doe demonstrates a marked lack of empathy in relation to the victims of his attack, both at the time of the attack and since. I also agree that empathy could be one of the ingredients in moral reasoning. The question is whether Mr. Doe's ASD impairments were sufficient to render him incapable of exercising a rational mind. In my view, notwithstanding his impairments, Mr. Doe was capable of rational thought, particularly given the length of time he spent planning this attack. I share Dr. Bradford's view that the NCR defense cannot be stretched to encompass Mr. Doe's situation. I do not see that Mr. Doe's fascination with mass murder sites on the internet or with Elliot Rodger or his ilk were sufficient to deprive him of an operating rational mind. It may have served to desensitize him to the horror of murder, and to believe there would be some people who would applaud such a crime, thus giving him some encouragement. However, he was nowhere close to delusional, nor was he in a dissociative state. His internet use alone was not sufficient to destroy his capacity for rational decision-making. The question then is whether, when combined with his ASD deficits, the threshold of rationality was crossed. I find that it was not. Mr. Doe's interest in mass murder was not a new thing. He had been visiting these sites on a regular basis since high school and fantasizing about doing a school shooting. Throughout all of that time, he did not act on his fantasies. Later, when Mr. Doe started following incel sites and getting more interested in Elliot Rodger, as well as sites featuring mass murders, he was well aware that the material on these sites would be unacceptable to almost everybody. He hid from others what he was doing. He said that he could not tell anyone about this interest because they would not approve and would reject associating with him. Nobody knew, not his best friend, not his brother, not his parents, not even others on the sites, as he hid his true identity when on there. To me, this shows that he was aware of the moral wrongfulness of this material throughout this time. Mr. Doe was clearly aware that his parents would be disturbed to know what he was planning, which is why he hid this from them. I find Dr. Woodside's evidence on this point to be highly persuasive. We already know that Dr. Woodside, in the justice's view, is sort of much preferable. And frankly, from the summaries I've had here, I kind of agree. Mr. Doe told him that he deliberately tried not to dwell on his parents' likely reaction because he really wanted to do this act. He also said something similar to Dr. Westphal, although Dr. Westphal chose to ignore it, and it does not appear in his report. Ouch. As Dr. Woodside testified, this is a kind of thinking most of us have done, realizing that there's a bad side to something we really want to do, but deliberately not thinking about that because you really want the good side. He likened it to the behavior of a pedophile. I suspect YouTube's going to be seriously annoyed with that word. Oh well. Who knows it is wrong to sexually assault a child, same thing, and knows it will be harmful to the child, but puts those thoughts aside because he really wants to perform sexual acts with a child. Yeah, I suspect YouTube is really going to be unhappy with that sentence. Whether we approve of the thought process or not, or consider the outcome desired by the accused to be repugnant, the reasoning process is nevertheless the exercise of a free and conscious mind, even though driven by the desire for something repellent to most of us. Crucial to my conclusion that Mr. Doe is capable of moral reasoning in relation to this attack is the length of time he spent preparing for it. This was not an impulsive act, nor was it an immediate reaction to some triggering action by someone else. This act was carefully thought out and planned over time. The evidence shows that it is in situations where Mr. Doe has ample time to think things through that he is most able to engage in abstract thought and moral reasoning. I recognize that Mr. Doe is also less able to use his intellect to reason his way through moral problems that are complex or novel. However, he's always been aware intellectually that murder is one of the most morally wrong things a person could ever do. Therefore, the concept of murder being morally wrong was not novel to him, nor was the idea of mass murder. He'd been ruminating about mass murder since high school. The moral prohibition against killing people was neither novel nor complex. Defense counsel argued that Mr. Doe's attack was, in effect, a split-second decision. Mr. Doe was nervous picking up the van, unsure whether he would go through with his plan. He got to the intersection of Young and Finch, which was not where he had originally planned to carry out his attack. However, he saw some people at the intersection and suddenly decided to run over them, speeding up, changing lanes, driving up onto the sidewalk, and doing just that. He then continued on his rampage as described. I do not agree that the sudden change in plan to start killing people at this intersection, as opposed to some other location, changes the nature of the attack. There was nothing special about the location other than there would be a lot of people and enough room to drive up on the sidewalk where pedestrians would be. He continued the attack exactly as planned, using the van he had rented weeks before, using the technique he had contemplated, killing as many people as possible, sending the Facebook message linking the attack to the incel movement, and then attempting to induce a police officer to kill him. This was not an impulsive split-second decision whereby he had no time to exercise rational thought or make a reasoned decision. His decision had been made already. He was now merely carrying it out. I tend to agree with Dr. Westfall's point that without ASD, Mr. Doe would not have committed these offenses. Mr. Doe's life would have been quite different if he did not have ASD, and those aspects of his life experience that led him to commit these offenses are likely inextricably connected to that diagnosis. So, for instance, his social isolation and, his loneliness is likely directly connected to his ASD, but that's not the test. As the court says, I emphasize, however, that establishing a Section 16 NCR defense requires far more than this simplistic but-for test. On the other hand, Dr. Wright advanced the interesting theory that Mr. Doe's actions might not be as connected to his ASD as everyone seems to accept. He noted quite a few similarities between Mr. Doe and the attributes associated with school shooters, as described in much of the scholarly literature in this area. Dr. Wright referred in particular to the classification system developed by Dr. J. Reed Malloy and others in an article written in 2001, and testified that Mr. Doe fit quite well within the category called Classroom Avengers. This is actually worth studying. If you have any interest in sort of this area, have a look at this research, which I'm vaguely familiar with, but it's worthwhile. According to Dr. Wright, common characteristics of school shooters include they are typically seen by their peers as loners, they have a history of being bullied at school, they engage in a lot of fantasy, they are preoccupied with weapons, and they often have served in the military. All of these apply to Mr. Doe, with the possible exception of being obsessed with weapons. The self-image of a school shooter often features self-reproach, another characteristic shared by Mr. Doe. Dr. Wright also testified that the extent to which Mr. Doe is haunted by his past failures is unusual for a person with ASD, but quite typical for a classroom avenger. Further, school shooters often fixate on another highly publicized mass killing and seek to emulate the perpetrator, and typically describe their offenses afterwards in a detached and chilling manner. Again, these are both features that fit Mr. Doe. Dr. Wright's point is that there may be more than ASD at play here, and more than one explanation for the lack of empathy and emotional connection displayed by Mr. Doe. Either way, however, Dr. Wright did not see the lack of empathy as something that could ground a defense under Section 16 of the Criminal Code, and I agree with him in that regard. I accept that when most people weigh the pros and cons of doing something that could injure somebody else, their empathy for the potential victim would be a factor they would take into account. I therefore also accept that empathy for the victim is one of the factors usually weighed in the balance in moral reasoning. However, I do not accept the submission of defense counsel that this is an equivalent situation to informed consent, where the absence of one piece of information negates the consent. It is the process of reasoning that is at issue when considering a Section 16 defense, and whether the person has the capacity to do so. The weight the person gives to empathy in that reasoning process, including that no weight at all is given to it, will not be sufficient to find that person not criminally responsible under Section 16. I really like that line. I think that's really powerful writing, and yeah, thumbs up. I like that bit of writing. I like that bit of reasoning. I like the logic there. Mr. Doe told Dr. Woodside that he used the incel material to rev himself up. He really wanted to achieve notoriety and saw mass murder as the way to achieve fame. He did this consciously and deliberately. As he laid his plans, deciding on a route, renting a van, working out the timing, he also kept everybody in the dark. He knew that if his parents found out, they would be shocked and devastated and would stop him from carrying out his plan. He therefore hid his plans because he really wanted to go through with the attack. Again, this was a conscious act on his part. Mr. Doe also kept all his options open. He accepted a permanent job and, on the same day as the attack, filled out employee information forms for his employer. I suspect that job offer has been rescinded. He completed writing the final paper due for his degree requirements and submitted it the day before the attack. Wonder how his grades were on that paper. Indeed, he selected the date for the attack based on when he knew he would be finished all of his course requirements. He planned with his brother to go out to celebrate after he graduated. He told assessors he did this because he was worried that he would chicken out and not be able to proceed with the attack. Unlike some of the experts who found it strange that Mr. Doe would continue writing a paper after he'd already rented the van to carry out this mass murder, I do not find this conduct to be surprising. Although Mr. Doe was doing planning and taking concrete steps towards the fulfillment of his long-standing goal to commit mass murder, he was still in active decision-making mode. If he did not go through with the killing, he needed to get on with his life, and he made plans accordingly. To me, this shows the functioning of a rational mind. Again, I think this is really a fairly insightful way of looking at this conflicting information. And this is a finding of fact, which is going to be very difficult to overturn at appeal. The reasoning here, I think, makes an appeal substantially less likely, and I'll talk about that a little bit more at the end. Dr. Woodside was cross-examined vigorously as to his lack of experience treating or assessing individuals with ASD and his failure to add another person to the team who was an expert on ASD. This alleged failure does not cause me to disregard or give no weight to Dr. Woodside's opinion. He is a highly skilled forensic psychologist, clearly qualified to provide an opinion on these issues. He was assisted in his assessment by Dr. Wright, who, while not an expert in ASD per se, does have quite a bit of experience with persons with that disability, as well as expertise as a forensic psychologist. Further, there was no question about whether Mr. Doe was correctly diagnosed with ASD. The issue was his capacity to know his actions were morally wrong and to make a rational choice. In my view, Dr. Woodside clearly had the expertise to offer such an opinion. On the whole, I found his testimony to be fair, balanced, and supported by the evidence. Dr. Woodside was also cross-examined extensively about the absence of any notes of his interviews with Mr. Doe. I accept Dr. Woodside's evidence as to the manner in which he takes notes and writes his reports. It is an unusual method. While interviewing the person being assessed, Dr. Woodside takes notes on his laptop. Instead of separately writing his report, he incorporates his interview notes into the report and then adds other things. Thus, there are no separate notes from the interviews themselves. Further, any revisions to delete things, amend them, or move them around would not be apparent to opposing counsel. I fully understand Mr. Bytensky's frustration with being unable to cross-examine by showing inconsistencies between what Mr. Doe told Dr. Woodside and what actually appeared in the report, a technique employed by the Crown when cross-examining Dr. Westphal with devastating results. As I said, the Crown on this one appears to be a highly skilled cross-examiner, and the justice is rarely missing an opinion, or rarely missing a chance to give her opinion on Dr. Westphal and his evidence. So, ouch. We've seen the word devastating come up a whole lot, and here's the justice dropping that bomb. I agree with the submission that it would have been preferable for Dr. Woodside to have kept a separate record of his interview notes. However, I reject the suggestion that he did this in order to protect himself from cross-examination. It is merely a habit he finds convenient and has used for many years. Ultimately, what Mr. Doe told Dr. Woodside is consistent with what he told everyone else, including Dr. Westphal. I do not find this method of writing adopted by Dr. Woodside to undermine the reliability of the information he gathered, nor the reliability of his opinion. In another case, it might, though, so this is a potential issue, but not here. Here, there were so many experts, and if they're all getting the same information, it's going to be really hard to attack this on the basis of maybe that's not what you heard. But if Dr. Woodside had been told something unique or special, that might have been a problem here. You didn't take any notes, and you're the only person who heard this detail? So, a little bit of a thought there. Ultimately, I agree with Dr. Woodside's opinion that Mr. Doe made a calculated decision to carry out this attack. Dr. Woodside recognized that Mr. Doe's ASD likely played a role in his actions, but stated that the deficits in his moral reasoning did not prevent him from knowing, indeed understanding, how others would view his actions. As Dr. Woodside pointed out, Mr. Doe's stated motivation included a desire to become infamous and notorious, which he said showed that at least at some level he appreciates that his actions will be seen as despicable by others. I recognize that, in this portion of his report, Dr. Woodside puts the test higher than it actually is, finding that Mr. Doe understood and appreciated the moral wrongfulness of his acts. However, even with that enhancement of the test in Mr. Doe's favor, Dr. Woodside was of the view that Mr. Doe did not meet the requirements of Section 16. I agree with the logic of Dr. Woodside's opinion. It is difficult to see how Mr. Doe can be said to be without insight as to how his actions were morally wrong when he deliberately relied on the horrified reaction of the public and the media to generate fame for himself. Conclusion. In this case, Mr. Doe knew it was legally wrong to kill people. He also knew that if his plan to run down and kill people constituted first-degree murder, and that if arrested, he would go to jail for the rest of his life. That's why his plan was to die by cop, death being preferable to jail. Mr. Doe knew that the vast majority of people in society would find an act of mass murder to be morally wrong. However, he desperately wanted to achieve fame and notoriety, believing even negative attention for his actions would be better than to live in obscurity. He had been fantasizing about a crime such as this for over a decade. He had no direct wish to commit suicide, and would not have done so independent of these offenses. However, he believed himself to be a failure, saw no hope for his life in the future, and did not care if he died, as long as he died while achieving fame. He considered the impact it would have on his family, and deliberately set those thoughts aside, ignoring them, because he did not want them to deter him from achieving this important goal. He was capable of understanding the impact it would have on his victims. He knew death would be irreversible. He knew that their families would grieve. At various times during his assessments by various experts, he described his actions as being devastating, despicable, shocking, morally terrible, a horrible thing, and irredeemable. Even if he only worked this out intellectually, without being truly able to fully grasp it emotionally or to have empathy, that is sufficient. It still demonstrates that he had a functioning, rational brain, one that perceived the reality of what he was doing, and knew it was morally wrong by society standards and contrary to everything he had been taught about right and wrong. He then made a choice. He chose to commit the crimes anyway because it was what he really wanted to do. This was the exercise of free will by a rational brain, capable of choosing between right and wrong. He freely chose the option that was morally wrong, knowing what consequences would be for himself and for everybody else. It does not matter that he does not have remorse nor empathize with the victims. Lack of empathy for the suffering of victims, even an incapacity to empathize for whatever reason, does not constitute a defense under Section 16 of the Criminal Code. I therefore find that the defense has failed to establish on the balance of probabilities that Mr. Doe was incapable of knowing his actions were wrong within the meaning of Section 16 of the Criminal Code. Mr. Doe is criminally responsible for his actions. Accordingly, I find Mr. Doe guilty on all 26 counts of the indictment. So, that is quite a decision. I know that I've been going at this for... I suspect this video is going to clock in at over 3 hours. I have a few more comments to make before I sort of wrap this up, because there's a few sort of issues and questions that people are likely to have. The first is, what about an appeal? And when I look at this, I mean, there are some potential avenues for attack on an appeal, but I don't think that they're likely to be successful. One of the things that sort of seems to open the door is a bit of the justice's comments with respect to the accused, and refusing to use his name in the, in the piece, taking time to sort of specifically focus on the victims before the legal analysis. That's really normally something that would occur more at sentencing than at the decision-making stage. Ultimately, I don't think there's enough there to ground a reasonable apprehension of bias argument. However, there might be more on this on a sentence appeal. We don't yet know what his sentence is going to be, but I suspect it's going to be life in prison, which is the mandatory minimum for this, with multiple periods of parole ineligibility to run one after the other. And if you're thinking about 10, 20-year periods running one after the other, that amounts to you never get out, because nobody has that kind of lifespan. So my expectation is that the sentence is effectively going to be that Mr. Minassian dies in custody without ever getting to say hi to the parole board. However, that may not be the case. And I think if he gets anything less than that, that there's probably not going to be much ground for a sentence appeal in any event. But in terms of appealing the conviction, I think that this decision is really well reasoned and really carefully reasoned. I don't see that it's likely that there's going to be any potential here to undermine it. It's possible that I'm missing it. It's possible that there's going to be something there that says, if there is an appeal, and there might just be an appeal just because of the stakes on this, but I don't expect an appeal to prevail based on what I see here. In terms of the expert evidence, I think that this is a really interesting case for talking about, how experts run in Canada, because we've seen that, experts in Canada are not supposed to be sort of a hired gun. They're not somebody who's on the defense team or the prosecution team, notwithstanding the fact that they may have been retained by one side or the other. They're intended to be facilitating a truth-seeking objective. And the justice had some strong criticisms of one expert in this particular case. I saw examples of what seems to be, the merit of cross-examination. It looks like the Crown was quite effective in cross-examination. And this is, there's been a lot of commentary about the disability-related aspects. Whether or not that this is going to say that people with autism are in some ways, defective or the like. I don't think that's what this case says at all. I think the justice was very careful to avoid that. It is worth noting that, there are deficits that can range from, minor or potentially sort of unnoticeable with accommodations and practice, all the way to very severe. The court has said, listen, we're not saying that autism can't ever count as the mental disorder necessary for an NCRMD defense, but it certainly doesn't do it in Minassian's case. And frankly, this judgment seems to close the door entirely on the whole, I lacked empathy, therefore, I can't be convicted defense. But there might be another person out there who is, not just lacking in empathy, but also lacking in the ability to reason these things out, to make moral decisions. And the court has left open the possibility that somebody in those cases could be potentially found not criminally responsible. In terms of the definition the court adopted for not criminally responsible by reason of mental disorder, it was one that I think leans more towards the defense. It wasn't sort of, I suspect, the one that the Crown was suggesting, which is just, does he understand that this was legally wrong? It was one that is more broad and more, has more elements that essentially could have led to the NCR finding. That also will make it harder for this decision to be appealed. It looks like every participant in the justice system here put in a lot of work, put in a lot of care. Again, I don't really hold truck with people who bash defense lawyers. I mean, I am a defense lawyer just because they take on difficult cases. I think that is quite the opposite. That's something to be commended. Everybody deserves a full defense, and frankly, society deserves it too. When I hear that there is somebody, a horrible killer in prison, I really want to be comfortable and confident that that horrible killer in prison is actually the horrible killer and not just some dude who got unlucky and whose lawyer decided that he wasn't going to fight this. Because that would also mean two things. I mean, one, it's horrible if somebody is in prison wrongly. But two, I also don't want the horrible killer sort of out there to be a horrible killer because we locked up the wrong guy. It's like the horror movie where they're like, yes, we have killed the villain. And it turns out that they just defeated some random guy. And, then there's the ending jump scare as you learn that, in fact, somebody else was really the killer and they're still going on killing. That's something I think we should avoid as a society. So I want to be able to have confidence that the people who are being punished had a good defense, and so that we know that they are almost certainly the ones who committed the offense and that they deserve the punishment that they're getting. And the only way we get there is with defense lawyers fighting this out. I'm also not going to condemn the Crown because the Crown did good work here. Quite frankly, there are several points where it's clear that the Crown just nailed it on cross-examination. And that's also part of the system. So good work on everybody involved. And the justice here put a lot of effort into this. That's why this is such a long video, but this is such a high profile and important case. I can tell you that, if you are going into law school in future, in your criminal law class, you're going to be ending up reading this case. I am almost sure of it. because there is so much detail put into the analysis of the NCR issues that, I mean, this is going to be a well-cited decision, I think. This is going to be a decision that has some weight. So anyway, I guess those are my thoughts. There's a lot to this video. I hope you're probably not watching it all at once. I certainly didn't record it all at once. You will have noticed a point where my shirt mysteriously changes color. Normally when I have to do sort of multiple days of recording, I try to set the shirt aside, but I spilled something on it, so hence the shirt change color. But yeah, I hope that this is one that you guys find interesting. I certainly found it interesting reading it over. It's a high profile case. It's one that's going to have a lot on, of impact on society. But yeah, let me know what you think in the comments below. Let me know if there's something else you want me to cover right away. I've got a little bit of a backlog because a whole lot of things have been happening, but I kind of wanted to get this one off my plate. Anyway, thank you as well to my Patreon supporters at the $50 level: D-Mo, Sir Daniel Wicks of Alberta, Canada's National Firearms Association, Jason Elliott, North Central Process Service, Jean-Guy Toussaint, and Kyle Martin. At the $20 level, Cameron Johnson, Dale Nesbitt, and Andrew Elsich. And at the $30 level, Sights and Arms Limited. I also want to thank all of my $10 Patreon supporters who will be in the crawl immediately following, including Up in Arms PAL training, who I found out just did a PAL course for a friend of mine. So anyway, yeah, that's about it. I hope this has armed you with knowledge, and see you next time for a video that will certainly be shorter than this one. Thank you once again for watching.